Conviction for life, custody more than 10 years.
IA for bail, my lord.
How many years he is convicted?
Conviction 17 ର appeal.
Mm-hmm.
17 ର appeal. CR ହେଲା 17 up to 17. 10 years ରହିଲାଣି.
Roughly 10 more than 10 years, my lord.
Pardon to mention, my lord. Sentenced to 20 years, already in custody for more than 7 years.
20 years and sentence for 20 years.
20 years.
It's not a division bench matter. It is a single judgment. Only life and death sentence, if it is imposed, then you mention. 20 years is assigned to single bench. Okay.
Sir, my lord. Appellant is in custody for about 18 years.
Give it.
And another is for about 12 years.
Give it. Those two matters which you have directed to be listed. Two of 90. Order sheet that is full. 2.90. Last order for is yeah, the report को मंगाई थी इसमें मैंने से जो report में मंगाई ना So how many dates we have heard this matter right from this is okay 7/5 then 8/5 then we pass that order on 8/5 25 ये ଗୋଟେ matter ଆଉ ଗୋଟେ କୋଉ matter item ଆଉ ଗୋଟେ କେତେ 2 our order sheet at April last order sheet was 3/5/24 there's your recall further cross examination ଶୁଣାଣି ହେଇଯାଇଥିଲା ଏଇଟା ଯୋଉ ଦିଟା ଡେଟ୍ ହେଇଛି ଏଟା ୱିକଲି ଲିଷ୍ଟ ଅଛି ତ ଏଟା ଆଉ ମାନେ ଅର୍ଡର ହଉନି ପ୍ରତ୍ୟେକ ଦିନର ଅର୍ଡର ହଉନି କିନ୍ତୁ matters have been matters have been so Mr. Das, there are two matters in the cause
1 and 2.
1 and 2 those I along with sitting with Justice Patnaik, we are hearing the matter is substantially it was hard.
Already over.
So what we are proposing to, we are referring it to the Honorable Chief Justice.
Constitute that bench also.
He said that no, this bench will hear, it's all right. If he says that no, it is
Yes, ma'am.
let us refer it because
yes,
for week 1 week or so we heard both the matters.
Already, ma'am.
So in these two matters, just take down. This matter was hard while one of us, bracket Justice S.K.Sahoo, sat in division bench with Honorable Justice R.K. Patnaik for days together. And it was adjourned after vacation. Let the matter be placed before the Honorable Chief Justice, whether the matter can be heard by the same bench or the bench which is now in sitting. So theta যাকো matter refer করবে theta item number 1 and লিখে দেবো when it was taken up last on such and such date. It was at last or later. লিখে দেবো draft. Yes, next now.
Allowed in item 2, my lord, copy of deposition may be supplied.
Hmm.
The lordship has remanded the court to the Lord trial
It
court, my
has
lord.
already been recorded.
Copy
Yes,
of
yes,
the
sir.
deposition.
I have already got. They have not received now.
The item number 2, na?
2.
It is stated that the deposition copy, the deposition.
Yes. हम कोई देंगे
Okay, it is stated by the learned counsel for the appellant appellants कर दिया उनको that as per the order dated 3/5/2024 the additional evidence of PW1 has already been recorded in the trial court and the same has been sent to this court and a copy of the additional evidence may be supplied to him. Rasi is the additional evidence. Let a copy of the additional evidence of PW1 recorded as per the order dated so and so be handed over to the learned counsel for the appellant. Upon the
Mr. Cha.
I have already taken.
learned counsel for the state submit that he has already received the copy of the additional evidence. It's
And
all.
to Mr. Chand for the GCI.
Acha, and so also the learned counsel for both Mr. Swanso and Mr. Chand, Himanshu Bhushan Das and Mr. Manas Chand. अच्छा. Okay, so these two matters now have to be placed before the Honorable Chief Justice. So now we'll come to item number 7. Okay.
Weekly list for orders, item number 7.
In this case, accused with the category since 21/7/2009, about to 16 years, more than 16 years.
Just a minute.
Initially, FR lodged
Custody since
21/7/2009.
you have your earlier bail application has not been rejected earlier by this court.
My lord, not rejected.
Then let us verify it.
Pending, my lord.
Okay, yes.
And as per rule submissions,
Please wait. No, your bail application was rejected on 37/2014 for the first time. 30/2014 rejected.
that was nothing.
There are two dying declaration made by the deceased was murdered after 2 months of marriage against the apparent prima facie. Okay. Then okay.
Now, day after tomorrow, also for the examination.
Judge nahi darkar nahi. A trial court record version. Final form देखो. Date of custody. क्या नाम हो चाहिए शंभू. शंभूर date of custody forwarding देखुची 21/7/2009 ठीक अछि. So you have never been released on bail. Order sheet देख दो आटी. Custody produced. Shambhu is produced in custody. He was being produced from custody. It is produce, Shambhu produce. Okay. So that means you have already 14 years. It's running 15 years, no?
FR was lodged in 498, 307, and 34 IPC during treatment.
That's who you are not.
In this case, no eyewitness. One co-accused also accused.
Are the learned counsel for the petitioner, learned counsel for the state. The learned counsel for the petitioner submits that the petitioner was taken into judicial custody on 21/7/2009. His bail application was earlier rejected by this court on 37/2014. And since the petitioner has remained in custody for 15 years, the bail application may be favorably considered. It is further submitted that though the paper book has already been prepared, but there is no chance of early hearing. Therefore, the bail application made. Land counsel for the state opposed the prayer for bail, considering the submission made by the land counsel for the respective parties. Period of detention of the petitioner in judicial custody and absence of any chance of early hearing, we are inclined to release the petitioner on bail. What is this two bail application you have filed?
Both are in custody right now.
No, my lord.
Arata release ହେଇଛି.
Acquitted.
Is it your judgment?
Shambhu hochi husband. Arata hochi uncle.
Wait. Judgment. How many persons were facing trial?
My lord. Dharanidhara Sahu hochi uncle 80 years old. Now he is dead also.
Then he has been acquitted. Counsel, come to page number 30. So only one person. So we are asking you why two bail application. Just a minute. Again, you go to the order sheet of the High Court where it was rejected 37. Miss case number. So that was pending. Then another bail application you filed. The 65 of 23 is the latest one. So এইটাও not press कर दियो 106 of 2016 है ना? This is not pressed. This order which has been passed today, that is in connection with IA number 65 of 23 है ना? Okay. Yes.
Item 8.
पासो कर दियो तो पहले ऐसे तो कोई में next same council.
In this case, well, judgment copy. Is item 8. We'll take it from pen drive. Judgment copy.
He is not there. Even if he comes, it will be taken out because it is for the entire week. So, yes, next. 9 is also the same council. You just come to the next one.
Item 10.
Then C. Kasturi BK Pani. Con order is the none appears for the appellant at the time of call. The impugn judgment is not stamped. The put has pointed out there is delay of so on. So land council. He has not read a copy of the appellant. But the land council for the state obtained specific instruction. It is a for you.
I have 10 instructions.
Whether the
Another
appellant
appeal was pending, that is JCRL 86 of 2008, and it is disposed of. Appeal dismissed. Same.
okay, same conviction. I have this. So this would go. Copy of the judgment enclosed करेगा ही. अच्छा. आसान करो. Judgment of Arthur. Secure same judgment की नहीं. Yeah. के नायक ठीक है जी.
ST number টা typography
FT ST case number 100. ওরা ভুলে গেছি 2012 500 2006 7 বৈকুণ্ঠ সিঙ্গেল প্ল্যান ওটা অল্গা কেস মতো এসটি কেস নম্বর 3213 ঠিক করেছি সেই নম্বরটা ভুলে গেছি এটা 212 অ্যাকচুয়ালি বৈকুণ্ঠ বিহারী টমসন son of Dileswa Johnson accused Bhattacharya Johnson stands charged the murder of Vijay Shankar Patel. The deceased in this case on 47 to 36. नहीं नहीं सही बीट अप कर रही थी जल तुमने काफी लेटर हो गई सेटा एजुकेशन की हां In pursuance of the order dated 6/5/2024, the Land and Council for the state has ଏଇଟା ଗୋଟେ ଏଇ ଜଜମେଣ୍ଟ ଗୋଟେ କପି ଦେଇଛି
ଏଇଠି ରଖିଦେଇଥିଲି।
ହଁ Land Council for the funds of produce the written instruction received from Senior Superintendent Circle Jail Sambalpur, which indicates that the appellant Vaikuntha Bihari Dansana, who faced trial in G, who preferred JCRLA number 86 of who has preferred this appeal, CRLA number so and so. Earlier preferred an appeal that is JCRLA number 86 of 2008, which was disposed of on merit on by judgment and order dated 21/6/2021, and the appeal has been dismissed. The Land Council has also filed the copy of the judgment pronounced by this court, which is taken on record, along with the written instruction. In view of such instruction received, this CRLA stands disposed of. এই जो जजमेंट रखी गोटे कॉपी आधे एनेक्स कर देकी नहीं टैग करी रखता
Item 11.
Please, Your Lordship.
11, I pray for Thursday. Then I will take the instruction. I have not yet received.
what instruction you want to take?
Regarding the criminal antecedent, and if they will be released, what will
Okay,
the case?
that was earlier.
And a notice to the victim if required, if he wants to appear in this case. So 3 things are there, my lord. I tried
Okay.
to contact the Mahila PS Sambalpur.
On that, as per that order, 21/5/2024,
Ma'am.
steps have been taken, but you
Yes,
want
steps.
it to be taken
Yes,
up
my
on
lord.
Thursday.
We have not yet received those things. Thursday, Your Lordship.
All right, it is there in the weekly list. We'll take up. First, खाली side रे लिखी देता. माने Satish Shah.
Item 12.
Well, I'm taken up day after tomorrow. In the meantime, I will solve the deposition copy.
You have got the deposition?
No, my
He will serve.
Day after tomorrow, and 26 तारीख. 26 तारीख डाकिए. 26/6.
Okay.
Item 13.
Pardon, madam. Madam, the petitioner is in custody since 2008, 19/1/2008.
Just.
No.
Yeah. How many appellants are there?
There are 3 appellants, and I am appearing in this JCRL is one person.
No. In this particular JCRLA,
One person.
one
My
appellant.
lord.
That is Happy alias
Aye.
Biralal Sahoo.
Aye.
So his custody date is
19/1/2008.
19/1/2008.
8.
So your bail application was not earlier rejected.
No, my lord. It was never taken up.
Let us see that. Let me tell this one. So either out of the final form question. This is item number 31 to the JCRL 48 put 5 in. JC. Yes, Biralal Sahoo. देखिए order sheet দেখি যাই নথিল তো ইয়ে আনালা হরিধর so and so produced in custody accused persons
Arrested on 19/1/2008.
8 हाँ मैंने 20 19 रे arrest ହେଇଛି 20 ରେ ପକଡେ ଖାଲି bail ରେ ଯାଇଛି ନା ଏଇରଲାରୁ produced in custody produced in custody order sheet order sheet ରେ So that would be for past line for custody. For us. The 16 ବର୍ଷ complete ହେଇଗଲାଣି
Others have already others were released from basic parent
ଅନ୍ୟମାନେ କଣ ହେଇଛି opposition
ଆଜ୍ଞା
ଅନ୍ୟମାନଙ୍କର
ଅନ୍ୟମାନଙ୍କ ସମସ୍ତ ଜଣେ ଖାଲି ଯାଇଛି ବେଲ୍ since 2012
ଆଚ୍ଛା
ସେ ଆଦିତ୍ୟ ବୋଲି ୟା ଏଥିରେ ଆଜ୍ଞା all total witness ହେଲେ 39
No, it's all right. We are just taking into account this period of detention. Yes, what do you say? 16 more than 16 years he is in custody.
My lord.
2008 ରୁ custody ରେ ଅଛି
My lord.
16 ବର୍ଷ 6 ମାସ
What is
ହେଇଗଲା।
his age?
ଆଜ୍ଞା
What is his age?
is right now say you
Judgment ରେ ଦେଖିଲେ halki ପଡିଗଲା 23 ବର୍ଷ ଲେଖା ହେଇଛି judgment ରେ 23 ବର୍ଷ ହେଇଛି ମାନେ young age ରେ ପଶିଛି ଆଉ
around about 40 years
so antecedent ଅଛି
Regarding
Nahi.
antecedent, no instruction, my lord.
କିଛି ନାହିଁ ଆଜ୍ଞା ତାର କିଛି ଘଟନା
are the learned counsel for the petitioner learned counsel for the state. The learned counsel for the petitioner submits that the petitioner is in judicial custody since 21/2008 and as such He has remained in custody for more than 16 years. And though paper book has already been prepared, but there is no chance of early hearing. Therefore, the bail application of the petitioner may be favorably considered. Learned counsel for the state opposed the prayer for bail. Considering the submission, period of detention of the petitioner in judicial custody for more than 16 years, and absence of any chance of early hearing, we are inclined to release the petitioner on bail allowed. Yes, next.
Item 14.
No one there. In council, not the next method.
Item 15.
May I please, on behalf of Mr. Pankaj,
Prisoner's petition at flag B for engagement of advocate Radhika Ranjan Bhattacharya, Mahima Shwain.
matter was listed before vacation. Your lordship was pleased to call for a report regarding the matter. If the petitioner
Just
will be
a
released
minute.
on bail.
After going through the information, we think it proper to call for a report. Inspector in charge of Jajpur police station regarding criminal antecedent, if any. Aschi on the
I have already sent the letter, but till late no instruction has been received. My lord, tomorrow, my lord, I will obtain the instruction regarding the same.
The report shall indicate whether there is any chance of creation of law and order problem with the accused is in. Okay, tomorrow.
My lord.
Item 16.
Around Misra. Not there. Next method.
Item 17.
May I please, my lord. My lord, the petitioner filed a IA for bail, my lord, since custody since 2nd March 2017, my lord.
Yes. କେବେ
2/3/2017.
2017.
Yes, my lord.
Earlier rejected.
No.
Very fine. Order admitted 2019 SC/ST matter notice sufficient ହେଇଯାଇଛି. Mrs. Sahu.
My lord. My lord.
Okay. Then on 25/2024, we passed that order. Okay, nobody is there. Now you can argue the matter on merit. You have got the deposition copy with you.
My lord.
So, what is the conviction and what is the sentence imposed?
Life for conviction, imprisonment for life for commission of offense 302 and 10 years for commission of offense 376(1) of IPC and 7 years, my lord, for commission of offense 32V of scheduled caste and scheduled tribe act.
So, what is the prosecution case?
Prosecution case is that on 24/6/2017 at about 2 p.m., the accused has took the deceased and her friends to witness the jatra.
Hmm.
And thereafter, her friends returned to house in a pickup van, and the deceased would stay with the petitioner, my lord. Thereafter, next day morning, they found the dead body of a deceased man
Where?
from near Jatra Padia.
Okay. So you are in the company of the deceased, and her dead body was found near Yatrapudi, as you said.
Yes, my lord.
So, in what condition the dead body was there? What is the PM report? Where is the doctor's evidence discussed?
Doctor evidence, my lord.
There is a sign and symptom of recent sexual intercourse, my lord.
So, को page रची कुहंतु?
Judgment para 11, my lord.
Page टा कुहंतु? Para 11.
Page 15, running page 15, my lord.
Okay.
11 on the last person.
There was sign and symptom of recent sexual intercourse, and cause of death was asphyxia due to strangulation. What is the age of the deceased?
This is 30 years, my lord.
30 years.
Yes, ma'am.
So this last scene stated by some witnesses.
Yes, ma'am.
Who are those witnesses?
Who were accompanied with the deceased.
Who
my
are
lord.
they? PWs?
My lord, PW2, PW3, PW4, my lord. Tinni jana aba.
What they stated that they came back and the deceased was in your company.
Yes, my lord. In the last, yes, my lord, at about 7 p.m., accused dropped me, Jayanti, the deceased in the Dasara Podia at village Karla in his bike, where one village drama was played. Thereafter, in 2 phases, Kabita and Hema and Janaki and Kunti were also dropped by the accused in his bike. We all watched the drama, and chief, my lord. We all watched the drama, and at about 3 p.m., the accused told us to leave the place, then arranged a Max pickup van and sent us to our village, and told Jayanti to drop her in his bike later on. ଏଇଟା ସମସ୍ତେ same ଜିନିଷ କହୁଛନ୍ତି.
That Jayanti is the deceased in
Yes,
this.
Jayanti is the deceased.
So that means the deceased remained with you.
Yes, my lord.
So this is one piece of evidence. And this doctor has given the PM. Who is the PM doctor?
PW12, my lord.
PW12, my lord.
PW12. What other evidence are there, Mrs. Sahu?
My lord. All are Kabita, Alamani, Kunti, Hemo. All the PW stated corroborated to each other, my lord. Corroborated to each other, my lord.
On this aspect, that
My lord.
Same thing.
My lord.
Same thing.
that he has
The
stated.
deceased
So,
were
last scene is one.
was last scene and also left, my lord.
Left means
Left with the accused or what?
Left with the accused, my lord.
okay. That's all right.
Last scene.
So last scene is
My
there.
lord.
Last scene is there.
My
And,
lord.
Medical evidence is there.
medical
My
evidence. Apart from that, any other thing is there?
No, my lord.
So it's a case of strangulation.
Yes, my lord.
So what is your explanation in the accused statement? When so many witnesses have stated that you are in the company of the deceased, who was subsequently found to have been raped and murdered by strangulation. So, what answer you have given in your accused statement?
Just
Accused statement of Arpala? Preparing this.
As per para 12, my lord. As per the 313 statement, my lord.
313 statement upon parachi.
No, 313. It was reflected on the judgment, my lord.
Oh, no, just a minute. PW2.
Different stands in his accused statement, my lord.
ମିଛ କଥା ଖାଲି କହିଛନ୍ତି ଆଉ କିଛି ନାହିଁ। ଆଉ କ୍ୱେଶ୍ଚିନ୍ ନମ୍ବର 3 ହଉଛି ସେଇ ବିଷୟରେ ପଚରା ହେଇଛି। ଆଉଥରେ ବାହାର କର ଆକ୍ୟୁଜ୍ ଷ୍ଟେଟମେଣ୍ଟ। ଏଇଟାକୁ ଏଠି ଗୋଟେ ହେଡିଂ ରହିବ ଆକ୍ୟୁଜ୍ ଷ୍ଟେଟମେଣ୍ଟ ବୋଲି, ବୁଝିପାରିଲ? ନୋଟ୍ କରିଦିଅ, ମୁଣ୍ଡ ହଲାଅ। ଆକ୍ୟୁଜ୍ ଷ୍ଟେଟମେଣ୍ଟ ଏଠି ହେଡିଂ ରହିବ, କ୍ଲିକ୍ କଲେ ସେଟା ଖୋଲିବ। What do you say, Mr. Rape and murder, and you are just in custody for 7 years. Are the learned counsel for the petitioner, learned counsel for the state? Case of rape and murder, the evidence of the doctor, bracket PW12, the judgment was a portion of article, paragraph 11. Indicates that there was sign and symptoms of recent sexual intercourse and the cause of death was asphyxia due to strangulation. Though the case is based on circumstantial evidence, but PW2, 3 and 4 stated about the last sin of the deceased in the company of the petitioner. And counsel for the petitioner submitted that petitioner is in judicial custody since 2/3/2017, and as such he has remained in custody for more than 7 years. And counsel for the state opposed the prayer for bail and placed the evidence of 2, 3, 4 and PW12. So and so we are not inclined to release the petitioner on bail, stands rejected.
Item number 18.
One is there. Next item.
Item 19.
Please use the mic properly.
Convicted under section 302 IPC and sentenced to life, my lord. And a fine of Rs 5,000 lordships. Here, that the in-laws are committed murder to his sister-in-law lordships.
Yeah, this man is Bipin Behera.
Yes, the husband of the my lord.
What is the name of the deceased?
This is my lord. Jhilli Behera, my lord.
Jhilli?
Yes, Jhilli Behera.
What is your date of custody?
Custody, my lord. 16/2/16.
16/2.
16.
2016.
8 years.
As for the doctor's evidence, what is the cause of death?
My lord, manual asphyxia for manual throttling. Asphyxia for manual throttling, my lord.
Without 12 men.
Yes.
He is the PM doctor.
Yes.
Without 12. Cause of death of deceased was due to asphyxia or manual throttling.
Finger pressure mark was there in Roman 2. It is there. Finger pressure bruises were there. Another finger, that is number 1, is also on the left mandible.
So kind of cross examination matter.
Who's cross?
Yeah,
Doctors.
yes.
Yes.
Para 3, para 4 lordships. The emotional abrasion may be caused due to contact with rubs. It is a fact that I have not mentioned in my report that I found the thumb impression in the wild pipe, but I have mentioned in thumb impression were found 3 cm below the mandible minor. Para 5, no accusers produced before me to verify their fingers. I found 3 finger impressions in one side and 1 finger impression on the other side. It is a fact that one person elbowed with the manual throttling. It is a fact that I have not mentioned in my report that there was a putness at a solid face and tongue was not protruded. But I have mentioned in my report that I found congestion on the face and skull. It is a fact that I have not mentioned in my report that I found bulging of eye, which is and found on the tongue and swelling of a tongue minor. It is a fact that nail injury may caused on the throat in case of manual throttling. But I did not find any nail injury on the throat of the deceased, my lord.
ନେଲ୍ ଇଞ୍ଜୁରି ଯାହାର ନେଲ୍ ଥିବ ତାର ନେଲ୍ ଇଞ୍ଜୁରି ପାଇବ। ନଖ ଯଦି ନଥିବ ତାକୁ ପ୍ରେସର କରିବ, ନଖଟା କୋଉଠୁ ଆସିବ ଦାଗ? ମନେକର ଏଇ ପୋର୍ସନ ଗୁଡାକରେ ଚିପିଲା, ନଖ ଯାହାର ବଡ ଥିବ ହୁଏତ ନଖ ଦାଗ ଆସିପାରେ। ତାହେଲେ ହାଉ ଇଟ୍ ଇଜ ସେ ମ୍ୟାନୁଆଲ ଥ୍ରଟଲିଂ ଲେଖିଛି ପିଏମ୍ ଇଏରେ ହୋମିସାଇଡାଲ ମିସ୍ କରିଯାଇଛି। ଆପଣ ତାକୁ ପଚାରିଲେ ଇଟ୍ସ ଏ ଫ୍ୟାକ୍ଟ that I have not mentioned the death was homicidal in nature but death was due to manual throttling। ଯଦି ସେ throttling ଟା ଲେଖିଲା homicidal ଲେଖିଲାନି ତାହେଲେ ତ manual throttling means it's homicidal। बाकी thumb impression
and again yes at para 10 para 10 he has given a suggestion. It is not a fact that death was not caused due to manual throttling and death was suicidal in nature and not homicidal in nature।
suicidal nature could पाइबे एथुरु एई जो इंजुरी ହେଇଛି
and this suggestion is again fatal। It's not homicidal in nature and not it is not a fact this is not means it's a homicidal। this suggestion is again fatal।
फिंगर प्रेशर आपनको स्त्री आपनको पाखरे थिला।
Out of 3 accused persons are there, 2 were acquitted and I am watching trial by lord।
No, it's all right। Where the dead body was found?
Laying in the room, my lord।
So in your room, bedroom?
Yes,
so
dead body was laying in the bedroom।
ଆପଣ bedroom ରେ ଆଉ କିଏ ରହିବ? How many years after marriage this incident took place?
Marriage, my lord,
Date of marriage is 10/3/15. Date of death is 16/2/16. 1 year.
କେତେ ହେଲା marriage ଟା କେବେ?
Marriage was 10/3/15.
ହଁ।
And date of death is 16/2/16.
Within 1 year?
Yes।
The other persons who faced trial along with you,
yes, sir,
they have been acquitted?
Yes।
They are your?
Mother-in-law, mother-in-law।
Huh?
Father and mother।
Oh, father-in-law, mother-in-law। ଷୋହଳ ହେଲେ ଆପଣଙ୍କର ହେଲା 8 ବର୍ଷ ହେଇଯାଉଛି।
8 ବର୍ଷ 4 months।
8 years 8 years 4 months। appeal pending କେତେ ବର୍ଷ ହେଲା? appeal pending ହେଇଗଲାଣି 5 ବର୍ଷ। Are the learned counsel for the petitioner and counsel for the state? The learned counsel for the petitioner submitted that the petitioner is the husband of the deceased, Jildi Behera, and he is in judicial custody 16 to 2016. A date ठीक अछि ना? A final
sir.
form पर देखी. देख दी क्या?
Yes.
16 to Vipin Behera, हाँ, like. And the parents of the deceased, judgment ati क्या मतलब? Trial court judgment. The parents of the deceased who face trial along with the petitioner have been acquitted by the learned trial court. The learned counsel further submitted that
The parents were living separate. They were living separately.
Yes, ma'am.
submitted that the case is based on circumstantial evidence and there is no chance of early hearing of the appeal in the near future and therefore the bail application may be favorably considered. Learned counsel for the state opposed the prayer for bail and submitted that the marriage between the petitioner and the deceased Jili Sao was solemnized on 16/3/2015.
Solemnized on
10/3/2015.
10/3/2015 and the deceased died on 16/2/2016. The doctor bracket the PW12 who conducted postmortem examination has opined that the cause of death was due to asphyxia or manual throttling and the occurrence in question took place in the bedroom of the petitioner and the deceased, and the petitioner has not offered any explanation as to how the deceased died. It is further submitted that the father-in-law and mother-in-law of the deceased were acquitted because they were residing separately and there was no clinching evidence against them. Considering the submission made by the learned counsel for the respective parties, nature of evidence adduced during trial, while not inclining to release the petitioner on bail on merit, but taking into account the ratio laid down in the case of Sejoletti versus State. Since the petitioner has remained in custody for more than 8 years and 4 months, and there is no chance of is released on interim bail for a period of 3 months. So he has to call for the report about his conduct from the concerned IAs. He is to surrender and produce the surrender certificate. All right. So this is item number 19. So it is interim bail granted for 3 months. Yes.
Item 20.
Please.
Yes, Ms. Naidu.
The appeal has been dismissed for default on 1st of October 2021.
1st of October 2021.
Lordships, and they have filed a miscase 1 of 2023 for restoration of the same, that is on 1st of January 2023.
कौन हला तापर किसी ऑर्डर है नहीं
সেটা আগে সেটা তো নোটিস অফ স্টেপস হ্যাভ টু বি টেকেন ইন দ্য মিসকেস
okay
with regard to the letter was with regard to extension of time disposal, সেটা it has been disposed of on default. That is no further extension necessary.
দেখুন period the later dated dated letter dated কেতে লিখি লিখছে letter dated হচ্ছে 11/6/2021 of the Commissioner of Endowment Odisha Bhubaneswar. in which prayer has been made like this one, so extension of time. On last order on 19/6/2024, we sought for instruction through Ms. Pratyusha Naidu, Land Council appearing for the Endowment Commissioner to obtain instruction as to whether the first appeal number so and so, which was directed to be disposed of by this court by June 2020, in the present writ petition regarding the status of so and so. The Ms. Naidu on instruction submitted that first appeal number so and so was dismissed for default on 1/10/2021, right?
Lordships.
And restoration application has been filed and in the year
2023, first 7th of January 2020. Given the order sheet as well.
Okay, 7th of
Order
January
sheet along with petition.
2023. And in that restoration application, notices have been issued to different parties.
Right,
Okay.
Lordships.
Yes, produce the order sheet.
As
The
well as
copy of the missed case number 1 of 2023, which are taken on record. In view of such state of affairs, no further an order is required to be passed on the application submitted by the Land Endowment Commission. Next. Communicate the order into some further. Yes. Italian.
Item 21.
May I please your lordship? My lord, here, my lord, the petition, the present appellant is in custody since 28/10/2011.
What is prisoner's petition, Ms. Tripathi?
My lord.
Flag X. I want to engage. Okay, she wants to engage you. Okay. You have filed your VNAM also.
Yes, sir.
All right, take down that paid you the prisoner's petition at Flag X, in which request has been made by the appellant. To engage Ms. Vijayalakshmi Tripathi as his advocate, and Ms. Tripathi has already filed his VNAMA. Therefore, the name of Ms. Vijayalakshmi Tripathi and her associates shall only be reflected in the cause list. The names of the other counsel will not be reflected. Okay. Yes, you can argue now.
Hello.
Argue the matter.
Yes,
You have just
the present appellant, my lord, convicted under section 302.
how many appellants are there?
My lord, there are 3 number of appellants at first trial, and namely Shankara Naik, Ranjan Kumar Naik, and Shiva Mahapatra. And Ranjan Naik acquitted by the London trial court during trial, my lord. And Shiva Mahapatra preferred separate appeal, and he was granted bail, my lord.
Just a minute.
CRL number 160.
Wait, please wait. So Ranjan acquitted.
Yes, my lord. Appellant.
Shiva separate appeal.
Preferred separate appeal in
what is the number?
In CRL number 165 of 2021.
CRL number 165 of 2021.
21, my lord.
He has been granted
bail, my lord.
By which order? Have you got the copy of that order?
Order, fine. This is the transfer matter.
Okay, he has been granted. We'll verify. Granted bail. Now, you are for the Shankar Naik.
Shankar Naik. I am for now, my lord, for the paying for bail for Shankar Naik.
Okay.
Shankar Naik, my lord.
This JCRLA.
No, my lord.
This CRLA.
CRLA number 283 of 21. My lord. This present appeal
memo. So this is filed by only Shankar Naik.
Yes, my lord.
So now, why you have filed 2 bail applications?
My
One
lord,
is IA number 1466 of 24. Another is, of course, earlier it was filed 551 of 2021. So you are to not press the first one.
Yes, sir.
2021. Lekhandu, IA number 551 of 2021. This is an application for bail. The Learned Counsel for the appellant submitted that since she has filed a fresh bail application, this bail application is not pressed. So this IA number disposed of as not pressed. Okay. Now, Shankar Naik is in judicial custody since when?
28/10/2011, madam.
2011. So this man was never released on bail during
No,
trial.
no, not.
Let us come to the final form. Verified. Shankar Naik. Shankar Naik is in custody since, okay, that is 29/10.
28/10/2011, madam.
Okay, you are right. But whether you are being released on bail during trial or not, record is accused person's name.
Not proceedings.
Wait, please have patience. Produced in custody, produced in custody. शिवराम को बेल लेथिले. Shankar produced in custody. You are right. The Shankar was never released on bail. So all throughout he was in custody. This would be your 2021. Whether a criminal appeal law, whether your bail application was earlier rejected by this court. 5-1. No. All right. No. So
Judgment passed on 23/2/2021. Thereafter, he preferred appeal, my lord. There, no bail application was.
What is the name of the deceased?
Deceased name Suresh alias Jogendra. Suresh alias Jogendra Patra. One deceased person.
So what is the weapon of offense?
Weapon of offense, my lord, that has not been seized, my lord.
Eyewitnesses are there.
Yes, ma'am.
Yes, my lord. PW8 claims as eyewitnesses to the occurrence.
PW8.
8, my lord. And the pistol had not been seized or produced before the trial court, my lord.
So what PW8 has stated that I along with so in a motorcycle for repair. Thereafter we mailed our king. When we are going on that near Jago, Bandhu, Sahi, Shankar came. Shankar came in a Bajaj City 100 motorcycle. In front of our motorcycle, he stopped the motorcycle. Okay, then just at that time, okay, Shankar uttered so and so, and he brought out a pistol from the backside of the vest and fired to Suresh on his chest. Okay, so you are that person who, according to the eyewitness, fired gunshot at the deceased. Who is the doctor?
PW9
PW9 doctor. Deceased died as a result of so-and-so due to above mentioned injuries. So the doctor has also found injuries, punctured wound. Okay. So the person whom you say that he has been released on bail,
Yes, ma'am.
In a connected criminal appeal, obviously he has just accompanied you, but you are the main person who fired gunshot at the
Yes, ma'am.
deceased. So your role is different than the other person.
Well, and the other independent witnesses are declared hostile, my lord.
What about the criminal antecedent? Because he has used the firearm. So have you obtained the
No.
to obtain
No.
criminal antecedent?
So besides that, my lord, the learned judicial magistrate, my lord, who conducted TI parade, he has also mentioned P 15, my lord. He has also mentioned that this present appellant was identified in the TI.
No, he has named. He has been named directly named. So
Yes.
PW 8 for PW 8, they are all known persons.
Yes.
So that
PW 8 has specifically stated that
you
the
just
name of the
we are adjourning it. You take instruction. Two things: criminal antecedent,
Yes, my lord.
it
Kindly.
is there or not.
Para 8.
Number two,
Para 8 of
whether his release would have any effect any on the society. That like the other ଅନ୍ୟ case ଗୁଡାକ ଆମେ ଯୋଉ ପାସ୍ କରୁଛୁ order ତାକୁ ଦେଖିକି ଲେଖିଦେବେ verify ଲେଖନ୍ତୁ the during course of hearing
my lord, PW kindly I may be I don't to mention PW 18 is the DSP who stated in his evidence
madam we are adjourning this matter
Fine.
to another date to obtain instruction about the criminal antecedent. Then we'll have the final hearing.
It has been mentioned, my lord, there was a antecedent, there was an
Let him take instruction about that. Let the learned counsel for the state obtain instruction about the criminal antecedent as well as whether the release of the petitioner on interim bail will have any impact on this one. So you say later the case.
Next.
So you produce the report on today is 24th. We are placing it on 8th of July.
Yes, sir.
List this matter we commencing from 8th July 2020. ଏଇଟାକୁ ନୋଟ୍ ଫେସ୍ କରିଦେଲେ ତ 500 ଠିକ ଅଛି
Item 22.
Last occasion, your lordship was pleased.
Please use the mic properly.
Last occasion, your lordship was pleased to call for the antecedent of the appellant.
That order
Because he is
dated
a
16/5.
man.
Learn counsel for the student. Okay. Criminal antecedent if any. कौन ଆସିଲା?
With reference to the subject cited above, I am to submit that on verification of criminal antecedent report of appellant Ishwar Chandra Behera from the available records of Boisinga Police Station, Mayurbhanj, nothing adverse is found against him. Besides this case, and also obtain the conduct report of the appellant from the Superintendent of District Jail, Baleshwar, in which he opined that the conduct of the life convict appellant Ishwar Chandra Behera inside the jail is satisfactory, who follows all the jail rules and regulations and District Jail, Baleshwar. The criminal antecedent report supplied by Inspector in Charge, Boisinga Police Station, Mayurbhanj, and conduct report supplied by Superintendent District Jail, Baleshwar in favor of the convict cum appellant Ishwar Chandra Behera are attached for kind.
Copy ଦିଅନ୍ତୁ ହେଲା ଯାହା ଆସିଛି instruction ଦିଅନ୍ତୁ. Yes, you can place now the matter.
The appellant, he is facing charge under section 120B, 121, 121A IPC and section 345 of the Official Secret Act 1923, and he convicted under section 120B, the operating part of the.
Since when you are in custody?
I'm in custody since since 2015, January 2015, my lord.
So you pass some secret
My lord,
information.
that is the allegation my conviction is based on the exhibit 22. What they are saying that is my interrogation report. Interrogation while they took me inside the custody and interrogate me, exhibit 22. The interrogation report is the only basis of conviction. Without even interrogation report was not put to me in 313 statement. No other circumstances, my lord.
You see, when the country is security,
that is your lordship.
that is
Obviously, but it's the matter of the
no,
national
that
security.
ITR Chandipur case, na?
Yes.
Okay.
And this this appellant, the whole conviction is based on exhibit 22, which is my interrogation report. And the two thing, my lord, they says that I had tried to contact with a phone number, but 9-digit number, but I failed. And another is, my lord, there is some.
You are contacting, as it appears, this Pakistan, this Karachi, Pakistan, all these things, and
nothing has been proved, my lord. This your lordship, running page 36, internal page 23 of the impinging judgment, paragraph 28. That what that the report that call for.
You see, in paragraph 18,
my lord,
it is stated that so-and-so resides at Karachi, Pakistan. Mobile number is this. Code check the number. True caller so-and-so. So that number is in the name of so-and-so. Pakistan even on today.
That is the to another accused. In respect, it is.
No, we say that how you say that there is no evidence at all except your interrogation. But apart from it's a case based on circumstantial evidence, and it's a matter which is based on this electronic evidence is there. So
electron from paragraph 22, then the interrogation report of accused
to corroborate the interrogation, there are other materials were also found. So
the my case has been discussed from paragraph 22 onwards. And paragraph 22, then the interrogation report of the exhibit, that is exhibit 22. So during my discussion, it is found that if your lordship will come to the conclusion in paragraph 22, 28, that I tried to contact to the person in a 9-digit number. That my in the finding is that it is the case record that the accused Ishwar Chandra Behra had tried to call on the 9-digit number but failed. This suspect is available in intercepted call all track number 5 marked as exhibit 17. And then
monetary transaction has been made.
Transaction, they say that one whole thing is that they say that one money 5,000 rupees come to me by I did not refuse, I did not receive due to that returned back. So how I will be liable for that? One and another I have a photographer. Several transaction, some persons have given 5,000, 7,000. Their rupees are there. That is, they are saying the monetary transaction in my account. So that is not relevant with the case.
Paper book has been prepared.
Paper book is prepared, of course,
not inclined. Are the learned counsel for the petitioner, learned counsel for the state. After hearing the learned counsel for the state submitted as per the instruction dated so on so that the petitioner has got no criminal antecedent and his conduct in jail is satisfactory. Is taken on record. After hearing the land counsel for both the parties and perusing the judgment and materials available on record, we are not inclined to release the petitioner on bail stands rejected since the paper book has already been prepared. The matter be added to the hearing list in due course. Yes, next.
Item 23.
My lord, it's kindly take up to it.
My prayer before Lordship, let your Lordship will hear this matter because
No,
already
2021. Why preference will be given to you? 2021 appeal it we are hearing here. Yes, next. Yes, what do you say?
It's kindly take up 2 weeks after.
Okay, this is item number 23.
Need copy of judgment may kindly be given.
Please give your pen drive, whatever you want, we will provide you. Don't ask them, the Land Council. The okay, prisoner's petition has come, madam. This for engagement of Advocate Debaki Marandi in place of Ellen Patel.
You are there.
You are so have you filed your VNAMA?
Yes.
देखिले जो मैडम करो you are Devaki Marandi, okay?
Yes.
मैडम करो वकालतनामा अच्छी तो अच्छी है. All right. Pay the prisoner's petition at Plaque C, wherein request has been made for engagement of Advocate Devaki Marandi in place of Advocate Ellen Patel. The VNAMA has also been filed by Swanso. The names of the earlier engaged counsel shall not be reflected in the cause list henceforth. The Land Council for the state submitted that he is not having the copy of the judgment on
Legible copy of the
judgment. On producing a pen drive, the legible copy of this one shall be supplied to him by the registry. Land Council for the petitioner seeks for an adjournment for 2 weeks. Put up 8 तारिखରେ रखिबा ना ଆଉ ଡେରି ଚାହୁଁଛନ୍ତି ଆପଣ ବର୍ତ୍ତମାନ ବେଲ୍ ପାଇଁ ଆସିଛି ପେପର ବୁକ୍ ହେଇନି ଏ କେସରେ 2022 ର ପେପର ବୁକ୍ କେସଟା କ୍ରିମିନାଲ ଆପିଲ ପେପର ବୁକ୍ ହେଇନି ଆପଣ ବେଲ୍ ମୁଭ୍ କରିବାକୁ ଚାହୁଁଛନ୍ତି ନା କେସ୍ ଆଡଜର୍ନ କରିବାକୁ ଚାହୁଁଛନ୍ତି ବେଲ୍ ପାଇଁ ଚାହୁଁନାହାନ୍ତି ତାହେଲେ ଯେତେବେଳେ ପ୍ରିପେୟାର ହବ ପେପର ବୁକ୍ ଆସିବ ଆଉ କଣ ହେଲା the matter be listed in due course କରିଦିଅ Land Council for the appellant submitted that the matter may be listed in due course. Yes.
Item 24.
May I please your lordship? My lord, offence under 302, 304B, 201 IPC as for FIR and what charge sheet is submitted for offence 302, 201 IPC. My lord, custody 8 years. 2/11/16. Sentence imposed for life and fine 50,000 my lord. Default under RI 2 years. Offence 302 IPC. And further sentence undergo RI for 7 years and fine and 50,000. Default under RI 2 years. Offence
Just a minute, Mr. Drip. Item number 24. SCRL 78 of 2025.
Prisoner's petition of chance super.
नहीं तो 24 नंबर
78.
हाँ JCRL 78. Already that has been regularized. See instruction ପାଇଁ ଥିଲା 25 ରେ ଯେତେବେଳେ matter ଆସିଲା ସେଇ order ଟା ଆମେ pass କରୁଛୁ ସେଦିନ ହଁ ହଁ so you have got the deposition copy etc. Okay.
Yes, ma'am.
So Mr. Tripathi,
yes.
So what is the conviction and what is the sentence imposed?
304, 302
You arrive for life 50,000.
Yes, madam.
Then 201 7 years 50,000 fine.
Yes, madam.
Okay, so you are in custody since when? 2/11/2016.
My lord, allegation on 13/3/2016 on the written report of appellant Soumyaranjan Behera, son of Ramchandra Behera, village Madhupur, the register UD case.
Please have patience. Please have patience. What is the name of the deceased?
Dinandini Behera, appellant wife.
What is the name of the deceased?
Binodini Behera.
Binodini Behera. The deceased is the wife of this appellant.
Male.
Okay.
Date of occurrence is 12/3/2016.
Date of occurrence 12/3/2016. So, what is the cause of death as per the PM?
Strangulation.
Strangulation.
His custody since 2/11/2016.
ନାଇଁ ନାଇଁ ଆମେ ଦେଖିଲୁ ସେଟା ଫାଇନାଲ ଫର୍ମ ଚେକ୍ କରିକିନି ନା ହଉଛି 2/11/2016 ତାମାନେ ଏଇଟା 7 ବର୍ଷ କେତେ ମାସ ହେଇଛି ନା so it's a case based on circumstantial evidence. So the dead body was found
inside the room.
In the bed.
Inside the room, hanging position.
In the hanging.
They
Okay,
tried to give a.
Let us see the doctor's evidence.
That is Dr. Miller 10 and 11 both Miller.
PW 10 and PW 11.
Miller.
That ligature mark was completely encircling the neck above the, so it was not in an oblique manner. So, and
cause of death is due to asphyxia by strangulation. Yeah.
ହାର୍ଡ ବୋନ୍ ଟା ଇଣ୍ଟାକ୍ଟ ଅଛି ବୁଝିଲେ ଥାଇରଏଡ କ୍ୟାଟିଲେଜ ସେକେଣ୍ଡ ପେଜ ରେ when there are the marriage between the petitioner and the deceased,
that is my lord prior to
Mr. Tripathi, when the marriage was solemnized?
2 years back. Last
2 years back.
Last page. His marriage solemnity with above, this is about 2 years back.
Any issue out of wedlock?
No issue.
No issue.
We don't 1, 2, 3, 4, 5, 7 are independent witnesses. 6, 9, and 15 are witnesses.
The independent witness might be telling that he committed suicide, but the doctor's evidence is otherwise. And doctor has seen number of scratch mark, then bruises and ligature mark. It is completely encircling the neck. So on the basis of this observation, he has opined it's a case of strangulation. What is your explanation when your wife is strangulated when she was in your company and the body is lying in your house? So what is your explanation in your accused statement? ମିଛ କଥା ସବୁ
ଏବଂ ଆଉ ଗୋଟେ ଇଏ ଯେ ମୁଁ ନଥିଲି ମୁଁ ଘରେ ନଥିଲି କ୍ୱେଶ୍ଚନ ନମ୍ବର 5 ମ୍ୟାମ୍
ଜଜମେଣ୍ଟ କେବେ ହେଲା?
8/8/2022
7 ବର୍ଷ ହେଇଛି ଜମା।
Hon'Ble additional session is 8 minutes. FIR 7 ମାସ ପରେ ଲଜ୍ ହେଲା ଇଡି କେସ୍ FIR registration after 7 months of ଇଡି କେସ୍ decomposed dead body
To move, you file another after some years. Let us see that. Like on Hard the Land Council, Mr. Ashutosh Tripathi on virtual mode, and Council for the State. The Land and Council for the petitioner submitted that the petitioner is in judicial custody since 2/11/2016, and as such, he has remained in custody for more than 7 years. It is a case based on circumstantial evidence, and the independent witnesses have stated that the deceased committed suicide. And there are good chances of success in the appeal, and therefore the bail application may be favorably considered. Land Council for the State, on the other hand, opposed the prayer for bail and submitted that the marriage of the petitioner with the deceased was solemnized 2 years prior to the date of occurrence, which took place on 12/3/2016. And though the independent witnesses have stated it to be a case of suicide, but the evidence of the doctors who have been examined as PW10 and PW11 indicates that there are a number of injuries noticed on different parts of the body, and the cause of death has been opined to be asphyxia due to strangulation, and it is homicidal in nature. And the dead body was found in the house of the petitioner, and no explanation has been offered by the petitioner as to how the deceased died a homicidal death. Considering the submission made by the London Council for the respective parties, nature of evidence adduced during trial, we are not, and particularly the post-mortem report finding, we are not inclined to release the petitioner on bail. Stands rejected. Stay of realization of fine allowed. Yes. Stay ପାଇଁ ଆଉ ଗୋଟେ application ଅଛି, ହଁ ସେଇଟା allow କରିଦେବେ.
Item 25.
Item 25, my lord, pray for 2 weeks after, my lord.
The IA number so this is an application for bail. London Council for the appellant seeks for an adjournment for 2 weeks. So you place this matter in the week commencing from 15th July then. 15th July 2024. Yes.
Item 26.
Appellants have been sentenced to imprisonment for life and fine of rupees 10,000.
No, it has come for condonation of delay. So he has filed an application, and the delay is just 5 days, as pointed out by the stamp report. And it's a life conviction, no?
My lord.
Life sentence has been imposed, okay. Yes, sentenced for imprisonment for life, fine 10,000. So we are condoning the delay, Mr. Lekhon. IA number so this is an application for condonation of delay. The stamp reporter has pointed out that there is delay of 5 days in preferring this criminal appeal. The Land Council for the state has no serious objection for condonation of delay, considering the submission made by the Land Council for the respective parties and taking into account the grounds taken in the interim application. And since it's a case where the petitioner has been sentenced to life imprisonment, we are inclined to condone the delay. Accordingly, delay is condoned. IA is disposed of. Admit call for the trial court record. You have filed the bail application, sir.
Bail application,
right. Application for bail and stay relation of fine to be considered after receipt of the trial court record. Yes.
Yes.
and Mr. Rashid Kumar Hota, Land Council through virtual mode from virtual High Court, Mayurbhanj Baripada. Yeah.
Public.
Item 27.
Already filed the IA for realization of 5% today. IA number 1513.
Is that available on the?
No, today I have filed.
Today you have
Yes,
filed.
madam.
So you want to move the bail application today?
No, next week.
Next week?
Yes, ma'am.
Okay.
In the mean-
That IA has been numbered? That
Yes, madam. 1513.
just a minute. IA number
1513.
1513 of 2024, right?
In the meantime, my lord, with custody, he's already in 7 years, 9 months in custody.
No, you said that you will move next week. So argue it next week. There is no problem. Ms. Rita Singh, Land Council, appearing for the appellant. Appellant or appellants?
Appellant.
One. Appellant submit that today, Aji file korichendi. Today he has filed an interim application for stay of realization of fine, which has been numbered as IA number 1513 of 2024. And he wants the matter to be taken up next week. Put up this matter, the week commencing from 1st July 2024, along with IA number 1513 of 2024.
Item 28.
P183 days delay. Same appellant has filed another criminal appeal in 2014. So why you again filed another when you were filed criminal appeal number so and so? So what has happened to that CRLA?
Admit and call for LCR.
Huh?
CRLA 720/16, my lord.
No. ଆପଣଙ୍କର ଏଠି noting ଯାହା ଦେଖଉଛି same appellant filed another criminal appeal CRLA number 386 of 2014 in which perhaps paper book has already been prepared. So whether that criminal appeal is still pending or disposed of?
Pending.
Huh? Disposed of it? ଏଇଟା ଅଛି ତ ଆଉ ଦିଟା JCRL କାହିଁକି ଆମେ entertain କରିବୁ?
No. CRLA 386/14, appellant number 3, file appeal, as well as CRLA 720/16, another appeal, my lord. Same appellant.
Total ରୁହନ୍ତୁ କେତେ ଜଣ ଲୋକ ଫେସ୍ କଲେ ଟ୍ରାଏଲ କି?
Trial face kale 30,
ଗୁଡା ଲୋକ ଫେସ୍
32, my lord.
32?
My lord.
अच्छा just a minute. ये ଏଇ ଯୋଉ JCRL ଆସିଛି ଏଟା ମୁନ୍ନା ମହାନ୍ତି ଫାଇଲ କରିଛି, ରାଇଟ୍?
Yes, madam.
ମୁନ୍ନା ମହାନ୍ତି କଣ ସେ ଯୋଉ CRL ରେ ସେ
Yes.
236 of 2014 ଟା ବାହାର କଲେ ଅପିଲ ମେମୋଟା। ମୁନ୍ନା ମହାନ୍ତି ତାର ଆପେଲାଣ୍ଟ ଅଛି। আচ্ছা 386 টা দেখুন 386 हाँ 386 ରେ ଆପେଲାଣ୍ଟ ଅଛି, ଆପେଲାଣ୍ଟ ନମ୍ବର 2। ତ ଆପଣଙ୍କର ଗୋଟେ ଆପିଲ ପେଣ୍ଡିଂ ଅଛି 386 of 2014 ରେ, ଆପେଲାଣ୍ଟ ନମ୍ବର 2 ହଉଛି ମୁନ୍ନା ମହାନ୍ତି। ତ ସେ ଆପିଲ ଆଡମିଟ ହେଇକିନି ପେପର ବୁକ୍ ତିଆରି ହେଇଗଲାଣି, ପୁଣି ଆଉ ଗୋଟେ କଣ JCRL କଣ ପାଇଁ ସେ ଫାଇଲ କଲା? ଏଇଟା ଟ୍ୟାଗ ଅଛି ତ ରେଗୁଲାର ଅପିଲଟା ଅଛି, କହିଛି ଗୋଟେ ଯୋଉଠି କହିଦେଇଛି ନାଇଁ ଫାଇଲ କରୁନି ତ ତାର ଅଲରେଡି ଫାଇଲ ଅଛି 386 2014. Tara Prasad Mahapatra is the counsel. Breakdown is your JCRL number 24 of 2023. This office has pointed out that the appellant Munna Mahanti has already preferred CRL number 386 of 2014, which is sub judice. We also verified from the records of CRL number 386 of 2014 and found that the appellant Munna Mahanti is appellant number 2 in the said CRLA. The paper books have already been prepared. Therefore, we are not inclined to entertain this JCRLA number 24 of 2023, which is accordingly disposed of.
My lord, CRL 720/16
720 of 2016 कौन चाहूଛନ୍ତି ଆପଣ?
ସେଥିରେ ପ୍ରିଜନର ପିଟିସନ ଅଛି ଚେଞ୍ଜ କରିବା ପାଇଁ ସେଟା ଆକ୍ସେପ୍ଟ ହବ ମାନେ
Business petition at flag D, praying for engagement of advocate Rajiv Misra. Mr. Rajiv Bihari Misra has also filed. Acha. Okay. CRLA number 720 of 2016 election. Review the prisoner's petition at flag D, in which prayer has been made for engagement of advocate Mr. Rajiv Misra as his advocate. Stop. Mr. Rajiv Misra and his associates have already filed Vinama for the appellant Kailash Chotrai. Single appellant. Prayer is accepted. The name of the Mr. Rajiv Bihari Misra and his associates shall only be reflected in the cause list henceforth. The names of earlier engaged counsel shall not be reflected. Yes, what do you want for?
I have for bail. I am already more than 16 years in custody, my lord.
Miss case number अच्छा जोटा 2013 of 2016 କହୁଛନ୍ତି
16 ରେ ମୁଣି ଆଜ୍ଞା
just a minute. CRLA 720 of 2016. Kailash Chotrai is the sole appellant.
my lord.
What is the date of custody?
Date of custody, my lord, 2006, my lord.
You are not aware about the date.
Charge was framed on 2007.
No. Final form baat from the trial court report. ଯେତେବେଳେ ପେପର ବୁକରେ କୋଉଟା ଆସିବ ଫାଇନାଲ ଫର୍ମଟା ଟ୍ରାଏଲ କୋର୍ଟ ରେକର୍ଡରେ ଥିବ
My lord, 54 of a paper book, 56 ରେ ଅଛି charge 21
charge family. We want to know that what is the date. We are to write the order. There should not be any incorrect reflection in the order sheet regarding your date of custody. So that's why we wanted to know about the. Okay, just a minute. Charge sheet टा देखिए ना. Charge sheet है. Charge sheet ଅଛି कि देखिए final form charge sheet की କିଛି नहीं. Okay, back करो back. अच्छा जी 1/11/2006. You said 2006. You're right. Commitment भी यही 2006 है. Okay, now you are to see that whether you have been released on bail or not.
Never release, my lord.
कैलाश छोटरा है ठीक है ସେଠି ଯାହା ଦେଖୁଛି କେବଳ ଗୋଟିଏ ଆକ୍ୟୁଜ ଥିଲା ନାଇଁ ନାଇଁ ବୁଦ୍ଧନାଥ ଜେନା is not produced in custody ଅନ୍ୟ ଗୁଡାକ ସବୁ ପ୍ରେଜେଣ୍ଟ ଥିଲେ ଇଏ କୈଳାସ କେବେ ଆଇଲା ବୁଦ୍ଧନାଥ ଜେନା ବାସ୍ ଗୋଟେ ଆଉ ଗୋଟେ କେସ୍ ରେ ହେଇଥିଲା ଏଥିରେ ରିମାଣ୍ଡ ହେଇକି ଆସିଲା ଇଏ ଓକେ ପ୍ରଡକ୍ସନ ୱାରେଣ୍ଟ ଇସ୍ୟୁ ହେଲା ହେଲା ପରେ ଏଟାର କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ ଆପଣ ଆଣନ୍ତୁ ଏଟା ଜଣା ପଡୁନି କ୍ଲିୟରଲି ଲେଖିଲେ ନା the Land Council for the petitioner submits that the petitioner is in judicial custody since 2006 let the Land Council for the petitioner এটা সেই 720 টার লিখবে let the Land Council for the state produce the custody certificate of the petitioner ହେଲା
which case, my lord?
এটা হଉଛି 720 ରେ ଆମେ ଅର୍ଡର ପାସ୍ CRLA 720 of 2016 हाँ सिंगल अपेलेंट कैलाश छोटरा है ना
Kala Chotte also before the appeal, my lord, 386. 386 of 2014. Noting is there also.
हाँ जे अच्छा ତା ଦେହରେ କଣ ହେଇଛି
ଆଉ ଗୋଟେ ବି କରୁଛି 236 14 ବି
No, no.
ନାଇଁ ନାଇଁ
386 ରେ 3 ଜଣ ଆପ୍ଲାଏଣ୍ଟ ସାର୍ କୈଳାସ ଛୋଟରା ହଉଛି 3 ସେ ବି କରିଛି ମୁଁ କହୁଥିଲି ଭେରି ଫାଷ୍ଟ
ଏଇଟାରେ ଅଛି 386 ତ ଆପଣ ସେଇଟା ଯଦି ଗୋଟେ ଫାଇଲ କଲେ ପୁଣି ଗୋଟେ କଣ ପାଇଁ ଫାଇଲ କଲେ 386 ଟା ବାହାର କଲେ ଦେଖିବା ହଁ କୈଳାସ ଛୋଟରା ତ ଅଛି ତା ଦେହରେ ଆପ୍ଲାଏଣ୍ଟ ନମ୍ବର 3 ଅଛି ପୁଣି ଆଉ ଗୋଟେ ସେପାରେଟ ଅପିଲ କଣ ପାଇଁ ଫାଇଲ କଲେ where is Mr. Tara Prasad Mahapatra ଏଇଟାରୁ ତା ନାଁଟାକୁ କାଟିଦେଲେ ହବ ସେ 386 ରୁ ଯେତେବେଳେ ପରେ ଏଟାକୁ ଡିଲିଟ କରିଦେଇ ତା ପାଇଁ ସ୍ପେସିଫିକ ଅପିଲଟା କଣ୍ଟିନ୍ୟୁ କରିବ ସେ ଆର ଦିଟା ପାଇଁ 1 ଆଉ 2 ପାଇଁ 386 ଟା କଣ୍ଟିନ୍ୟୁ କରିବ 386 ରୁ 3ଟା ଆପ୍ଲାଏଣ୍ଟ ଅଛନ୍ତି
386 ରେ ହିଁ ବେଲ୍ ହେଇଥିଲା ଯୋଉଟା ରିଜେକ୍ଟ
My lords,
386 रे बुद्धनाथ जेना मुन्ना महांती कैलाश छोटरा रे जेहेतु कैलाश छोटरा एटाकू ए अपील टा फाइल करानी सेपरेटली ताकदेरु काटी ए अपील टा कन्फाइन कर देले से दी जण पय हबो बट लेट हिम ऑब्टेन इंस्ट्रक्शन तो आपण 720 रे इंस्ट्रक्शन टा नै जानतु जे अबाउट द कस्टडी of this man and criminal antecedent also you take instruction because as it appears from the order sheet he was taken on remand in this case so there must be some other case also okay
SSB
kothre
236 minute of instruction to appear CRLA 236 that is Kailash Patra
in matter 236 matter I have received one report regarding the Tito Das Kiran Krishna Das matter appellate number 3
no we are since other counsel are not moving bail application this Kailash is moving bail application so we are you are to produce CRLA number 720 of 2016 re custody certificate number 1 number 2 about the criminal antecedent hala dekhi dele na
My lord.
yes
My lord, as director earlier, I had filed an IA for the condonation of delay.
which one
That is not tagged, but IA number 79 of 2014.
70
79.
79
JCL drop
JCRL 24 of 23.
24 it has been disposed of it has been disposed of because he has earlier filed an appeal that is CRLA number 36 of 2000 kita ame jo indicate kolu hela
ସେଥିରେ ମୁଁ IA ଟା ଫାଇଲ କରିଥିଲି
ha
24 of 23 ରେ ମୁଁ IA ଟା ଫାଇଲ କରିଥିଲି
24
JCRL 24 of 23 ରେ ମୁଁ IA ଟା ଫାଇଲ କରିଥିଲି
ठीक है सेटा तो डिस्पोज ऑफ हेगला जहां आईए सब डिस्पोज ऑफ हो यस नेक्स्ट
Date kindly fix, my lord.
Mr. Das will take up this matter on 8th. All right. 8th of July 2024. So custody certificate. I would have criminal antecedent.
I mean,
password ki option
CRLA number.
Which one you are moving, Mr.?
So I am in serial number 649 of 2019.
Item?
Whereas item 20, 29.
29.
For admission.
That is
That
for
has been admitted.
Already admitted.
Admitted IA for bail.
IA for bail.
Bail ta beti admission bhi kon purila to. What admission? Admission he jeichi bola कहउछन देखिले 7 wait 780 kon admission है नहीं
8 man.
Let us see. Please wait. 780 of 2019.
Delay kando.
Delay kando nahi.
Admission है नहीं
ना delay kando.
এটা কোন life imprisonment?
Life imprisonment. Life imprisonment.
Wait.
Five appellants in 5 different appeals. Connected to the same GR case and
we have to first admit it. It has not been admitted. All these appeal have not been admitted.
All these 3 appeal have been admitted. They have been extended.
780 টা admission ହେଇନି ପରା ଆମେ ଦେଖି ସାରିଲୁଣି
780 ଟା ହେଇନଥିବ ମୋଟା ହଉଛି 649
just a minute we are going to step by step ଏଇଟା ଦେଖନ୍ତୁ ତା ପରଟା ହଉଛି 649 ଟା admit ହେଇଛି କି ନା ତା ପରଟା ଏଇଟା ଆଚ୍ଛା या देरे दीटा अगर सिंगल अपीलेंट अछंती 780 of 2019 और ये
समत इंडिविजुअल फाइल करछन इधर 649 2019 ने मोकला
All right. Dita का appeal करने तो hard admit कर दिया.
LCR ଅଛି.
LCR टा बुझी पाना दी admission न है कि नहीं LCR टा call for ही थला. But appeal has to be admitted thereafter.
actually कौन है जी कि CRLA नंबर 503/2019 522/2019 545 2019 तीनटा जगह एडमिशन पे आसला सेथरे मगा आइतला LCR टा
ठीक अछि ठीक.
सब तक टैग अप हेतल बोली LCR टा ठीक आसी
या संगे गोटे आउ गोटे tag of matter अछि केते नंबर सेटा
780 को
Mine item is 780.
780 ଆପଣ ଅଛନ୍ତି
ମୁଁ I
780. So you are to move the application for bail.
yes
Yes.
ma'am.
That is IA numbers 1708 of 2019.
Yes, my lord. In this case, my lords, CRLA number 503 of 2019, the main culprit, he has been extended.
ଆପଣଙ୍କର କେତେ ନମ୍ବର ଟା?
ମୋଟା ହଉଛି 649 fourth serial ଟା 649.
Just a minute. Mr. Das,
No.
you have received the
Let it day after tomorrow because because this is on admission.
अच्छा
Then
अच्छा
nothing for
heading
place
कर दो.
admission
Order से आसियो.
and
All right. Put up this matter next week for orders कर दो.
in this case we have already served the date set and
ठीक ଅଛି.
everything.
ए दीटा अगर admit करिवे हैं और next week रे orders ପାଇଁ चले से for consideration of the bail application and application for stay of realization of fine next week. Yes.
Both the cases, man.
Both the cases. Item number 3. So, where is Mr.
Item number 30. I could not take the LCR pen drive. The clerk has left the job.
13.
They have taken the 30, sir.
30.
नहीं sir pen drive.
Just a minute. Just a minute.
Double piece.
हाँ कौन क्यों चंदी?
Pen drive रे नहीं नोटली sir. The clerk has left the job. I will take the LCR on through pen drive next week.
You want it urgent?
Yes, ma'am. Next week. I will take the LCR through pen drive.
order टा देखी दो. Last order टा कौन है देखी?
Last for direction देखले pen drive नहीं है.
So okay. हाँ नहीं ना दी ना?
नहीं से clerk sir छाड़ देला काम से रखला pen drive.
Learning counsel for the petitioner submitted that even though there was an order on 18/6/2024 directing the registry to supply the LCR of the settlement revision cases to him in his pen drive, but he could not produce the pen drive, and will produce it during course of this week, and the matter may be taken up next week, right? Put up this matter in the week commencing from 1st of July 2020. Item number 3. This is that part-head matter. So, where is Mr. Sodangi? बाहर ना दीजिए. We are going to date reference cases. So this is takes time. So
Mr. Sarangi has not come.
Oh,
busy. Oh, good.
Sorry, Millers, because of some unavoidable circumstances, I have to leave. I was there.
Weekly list item number 3.
May I please, Your Lordship? Yes, may I please, Your Lordship? Your Lordship, I am just taking Your Lordship to the extrajudicial confession part. What Your Lordship has already noted, but PW1 has stated at page 67. Page 67 was sixth line from the top.
Which one is there?
Page 67 of the paper book. Have you also got it?
Yes.
Sixth line from the top. The accused persons were telling loudly that the accused persons were telling loudly that they have killed my brother-in-law Giridhari. And out of fear, I, along with my niece and nephew, entered inside the house and closed the door. This is PW1. Then you'll also get it at page 75, so far as PW3's version is concerned. plus the third line from the top. This so far as PW3's version is concerned.
PW
3. Sachin Sahu was the son of this is
page 75.
75 plus. Third line from the top. Accused Nabin Dehuri was telling loudly that they have also killed Kiri Maria. As because he belongs to the village Kirimira, that's why he was being called in that village as Kirimiri. Then so far as PW4 is concerned, you'll also get this can come to page 78. Accused Nabin Dehuri plus the first paragraph, last 2 lines will also be. Both of them were lying dead there. Accused Nabin Dehuri was shouting and telling that he has killed Kirmiria. So these are the statements that can be, those are extrajudicial confessions and admissible under section 8 of the Evidence Act. Now for a moment I am taking Lordship to the chemical exemption report.
So, Mr. Katkia, suppose one accused was going on the road. He was just telling that I have killed Mr. X. And in fact, afterward it was found that X has been X has died, and um, it was also found on the basis of the post-mortem report finding that it is a homicidal death. So this conduct of the appellant in shouting on the village street, according to you, it would be an extrajudicial confession plus conduct under section 8 of this one.
Yes, and that is coupled with the the evidence come up through the chemical examination report. His shirt was carrying white striped green colored lungi that was of Nabin, that was carrying blood extent patch of group B. That I'll take a lordship to the chemical examination report.
Yes, C report ର finding होउची आर जो shirt टा
यार गोटे white striped green colored lungi पिंतला that will also get to page 147. That is stained with blood, extent patch, origin human, grouping B. There's a patch of blood.
कितना number serial?
147, serial number 5 loss. D.
Human blood.
It is human blood, grouping B.
Group B.
Grouping B.
D is lungi. तार सेटा lungi.
Lungi. Next serial number 6 रहउची तार
lungi of से जो नवीन रो.
नवीन रो. D.
ता पूर्वरु अछि पेज रे 146 रे.
ता पूर्व अछि.
D टा होची ए जो 5 number serial टा मार्क हेची लुंगी
141
ଆଉ 141 ରେ ସେଟା ଦେଖଉଛି ଏଟା होची जोटा D सेटा मार्क हेची सेटा होची one white stripe green
color lungi of accused Navin Deuri having
blood stain. So D is 141. Page 146 and 147. A D टा होची नवीन देउरी रो.
Navin plus next E you also can find. He was wearing a vest that was carrying also blood. 6, serial number 6. Next one. That is blue faded vest of accused Navin with blood stain. That is also human origin and grouping AB.
E.
That AB is the blood group of Giridhari.
Where from you got it?
Plus that AB grouping, it is a group AB na. Plus it is a grouping AB.
नहीं आपण AB टा गिरिधर रा blood group बेली कोड पाई.
Yes, plus that is you also get it page 150.
Your report.
Yes, chemical example 150. Serial number 35 on the top. That is S. That is blood sample of Giridhari.
कोडा?
Plus page 150.
S.
On the top 35. Marked as exhibit S. This is of Giridhari. You'll also get it as 143. Page 143.
143.
Yes. S. What is S?
Blood sample of Giridhari.
Yes, boss. Then S, S1, S2. S1 is the hair sample. S2 is the nail clipping, nail sample.
143, page 1. Okay. What is his own blood group? That means Nabinra blood group ke kaun?
Nabinra blood group, you also get it as that is B. That is serial number 13 plus at page 148.
White
J2.
green color.
J2. Serial number 13 J2. 148 page.
J2, seta.
That you'll also get it as 142.
142. J2 पाइलु तार कौन बाला opinion J2 रे opinion कौन असला J2 असला grouping B.
Yes, that is grouping B.
Only B.
Only B. Pirovati, Savitri, and Nabin. They are having blood group B. And Nabin and that Dehuri, he is having the blood group of AP.
Giridhari होची AP.
AP.
ତେଣୁ deceased ର blood group ଟା ମିଳିଲା ଆର
Best true.
best ରୁ
ଆଉ B ରୁ ଯୋଉଟା ମିଳିଲା ତାର ଲୁଙ୍ଗି ରୁ, that is group B, that may be of Savitri or Pirovati, because he has not taken a stand in the that I was injured in the
313 statement stand নাই
ନା
ମୁଁ ନିଜେ injured ଥିଲେ କି କଣ ହେଇଥିଲେ ସେମିତି
ନା
କିଛି ନାହିଁ.
ସେ rather
But
କହିକି ମୁଁ ନଥିଲି ସେଥିରେ.
the blood group of the other two have not been taken.
Yes, Master. And I'm giving lots of time.
ଏଇ ଯୋଉ ଆର ଦିଟାର
J2 ହେଲା plus J2 ଟା ହଉଛି ନବୀନ ର,
ନବୀନ ହେଲା
K2 serial number 16. K2 ଟା ହଉଛି ହେମାନନ୍ଦର.
K2
ଏଟା O grouping O.
ନାଇଁ ନାଇଁ ଯୋଉ ଆର ଦିଟା deceased କଥା
ଆର ଦିଟା deceased, you are also will get it on page 149. That serial number 29. Q.
149.
That serial number 29. Madas exhibit Q. Blood sample of Pirovati. It is Pirovati. You will also get it at page 143.
এটা পিরবতীর
Pirovati.
তার এটা হচ্ছে কিউ বলে কোড
Q, then Q1 is তার hair sample, Q2 is nail sample. ସବୁଠାରେ human blood ଅଛି. There no opinion, but blood sample ଆସିଯାଇଛି group P.
আচ্ছা এটা হলো deceased পিরবতী blood group ହେଲା B.
Yes, B.
এটা ପାଇଁ ହେଲା page ହଉଛି 143 serial number 28 ହେଲା 28 ଆଉ page ହଉଛି 149 149 serial number 29 এটা হচ্ছে deceased টা আসিগলা এটা হচ্ছে 143 ରେ serial number 34 ଆଉ page 150 finding ହେଲା 35 ଆଚ୍ଛା ଆଉ ଗୋଟେ
R plus 32.
deceased
Serial number 32 R.
32 na 31?
32 plus. 31 is Q2. Q1, Q2. That is nail clipping.
31.
Q1, 32 ହଉଛି blood sample of Savitri.
This is Savitri.
You will also get this page 143.
Yes, yes.
Page 143 serial number ହେଲା
31, 32, 33.
नहीं blood group टा होची
Blood sample.
Yes.
28 नहीं sorry Savitri ହେଲା 31
The group B.
page 131 plus 31 ଆଉ finding ଆସିଲା କେତେ page
149.
What?
149
Serial 32.
2 color B.
They have taken like this Q1, Q2. Q is the blood sample, Q1 is the hair sample, Q2 nail sample. Likewise, R1, R2 of Savitri, R1 is the hair sample, R2 is the nail sample. Likewise, S is the blood sample of Giridhari, and S1 is the hair sample, and S2 is the nail sample. In this way, they have taken.
ତିନିଟା ଡିସିଜ୍ ର ହେଇଗଲା ଆଉ ଆର ନିଜର ହଉଛି ଏଇ ଯୋଉ ନବୀନ ର ଏଟା ଆପଣ କୋଉଠି
J2 page 148 available. Group B.
J1, J2.
Yes.
10, 11, 10.
ନବୀନ
ସେଟା ସେମାନେ କରିଛନ୍ତି 140
ହେଲା
142 page ରେ
ଆଜ୍ଞା
serial number 10.
page 142 ନାଇଁ 10
nail
ହଉଛି
clip, ତାର nail clipping, blood sample
ଏଇଟା
ଏମିତି
ବ୍ଲଡ
କରିଦେଇଛନ୍ତି।
ଟା ହଉଛି 12 ନମ୍ବରଟା
ହଁ 10, 11, 12 ଟା ହଉଛି J2
ବ୍ଲଡ ହଁ J2 ଟା ହଉଛି ବ୍ଲଡ ସାମ୍ପଲ ର ଏଇଟା ତାର ଫାଇଣ୍ଡିଂ ଆସିଲା କେତେ ପେଜ ରେ J2 ର
J2 finding ଆସିଲା 148 ରେ 148 serial number 13
ହଁ 148 okay so whether question has been put that the lungi which was seized from you
yes
and the
Your-
vest which was seized from you was carrying were blood stained and it was found to be of blood group so and so
Your also can come to page 23
accused statement
page 23 of Hemanand of Hemanand
ଏଇଟା ହଉଛି ହେମାନନ୍ଦର ନବୀନ ଆସନ୍ତୁ
23 question number 4
ନବୀନ ଆରମ୍ଭ ହେଇଛି 43 ରୁ
ଆଜ୍ଞା 20 yes
page number 43
ମୁଁ ଆପଣ ନେଇଯାଉଛି question number 4
54, 55, those was, what is that? 50, Sorry.
E30. 30.
There is no evidence of it of 10. Question 41. A bright green color lungi, one blue color padded vest, one green color t-shirt, one green color pant. Then acts were produced before her with requisition of the IO to conduct chemical exam. Then 42. Then 43. Result of chemical examination.
P16. এটা ক্ষেত্রে আছে P16.
So far, biological samples are concerned. Page 59, para 67.
Yes, 67 is also there.
Right.
Question 67. A collection of the biological material. But
ଆପଣ ଯୋଉଟା କହିଲେ ନା ଯେ ସିଏ କହିନି ଏଇଟା ମୋ ରକ୍ତ ବୋଲି, ମୋ ରକ୍ତଟା ଲାଗିଛି ବୋଲି, ଆପଣ ପ୍ରଶ୍ନ ବର୍ତ୍ତମାନ ଯାହା what has been pointed to out, ଆପଣ ଯଦି ତା ଫାଇଣ୍ଡିଂ ଉପରେ ଯଦି ପ୍ରଶ୍ନ ନ ପଚାରିବେ ସେ ଉତ୍ତର ଦେବାର ସ୍କୋପ କୋଉଠୁ ଆସିବ? ଆପଣ ଯଦି କହିଥାନ୍ତେ ଯେ ବାବୁ ଦେଖ ତମଠୁ ଯୋଉ ତମର ଏଇ ଯୋଉ ଲୁଙ୍ଗିଟା ଜବତ ହେଇଥିଲା, ଭେଷ୍ଟଟା ଜବତ ହେଇଥିଲା, ସେଇଟାରେ ଯୋଉ କେମିକାଲ ଏକ୍ସାମିନେସନ ପାଇଁ ଯାଇଥିଲା ତାର ସେ ଭେଷ୍ଟରୁ ଯୋଉ ବ୍ଲଡ ଗ୍ରୁପ ମିଳିଲା ସେଇଟା ହଉଛି ସେ ଡିସିଜ୍ଡ ଗିରିଧାରୀର ବ୍ଲଡ ଗ୍ରୁପ, ଯୋଉଟା କି ଇଏରେ ଏଇଟା ପଚାରିଥିଲେ ସେ ଯାହା ରିପ୍ଲାଏ ଦେଇଥାନ୍ତା କି ତମର ଏଥିରେ ଲୁଙ୍ଗି ଏଗୁଡାକ ଯଦି ନ ପଚାରିବେ, ଆପଣ ଖାଲି ସିଜିଅର ପଚାରିଲେ ଫାଇଣ୍ଡିଂ ଆପଣ ଖାଲି ପଚାରୁଛନ୍ତି ଗଲା ଗଲା ଏସବୁ ଗଲା, ଏକ୍ସପ୍ଲାନେସନ ଜଣେ ଦବ କେମିତି ଯଦି ଗୋଟେ ସ୍ପେସିଫିକ କ୍ୱେଶ୍ଚିନ୍ ହବ ନା ଏଇ ବ୍ଲଡ ଗ୍ରୁପ ସେଇ ବ୍ଲଡ ଗ୍ରୁପ ଲାଗିଥିଲା। ତେଣୁ during course of argument you made a submission that he has not taken a plea that it is his own blood group. ଲୁଙ୍ଗିରେ ଯୋଉଟା ଏଇଟା ଯଦିଓ ତା ବ୍ଲଡ ଗ୍ରୁପଟା ବି ଏବଂ ଦିଟା ଡିସିଜ୍ଡଙ୍କର ବ୍ଲଡ ଗ୍ରୁପ ବି, କିନ୍ତୁ ସିଏ କହୁନି ଏଇଟା ହଉଛି ମୋ ବ୍ଲଡ ଲାଗିଥିଲା, ତେଣୁ ଏଇଟା ହଉଛି ସେ ଦିଟା ଡିସିଜ୍ଡ ବ୍ଲଡ ଲାଗିଥିଲା। କିନ୍ତୁ ଆପଣ ପଚାରିଥିଲେ ହୁଏତ କହିଥାନ୍ତା।
But even if that question has not been put, in no way the accused is being prejudiced, because in this case
ସି ରିପୋର୍ଟର ତାହେଲେ ଆପଣ ଡିସିସନ ଦେଖାନ୍ତୁ। ସି ରିପୋର୍ଟର ଫାଇଣ୍ଡିଂ ଯଦି ବିନା ପଚରାରେ whether it can be used against the accused, এটা ହଉଛି ଆପଣ ପ୍ରପୋଜିସନ ହେଲା।
Yes, has the
knowledge about the series.
Yes, because section 293 it is admissible in evidence. That part is very clear. If it has not been put to the accused whether he is being prejudiced, in this case my humble submission is he is not in no way prejudiced. If an explanation can be given, the counsel appearing for the accused, he can give the explanation the how he is being prejudiced.
No, ଏଠି କଣ ହେଇଛି ନା ଆଉ ଗୋଟେ କେସରେ ବୋଧେ ମିଷ୍ଟର ଦେବାଶିଷ ପଣ୍ଡା ଯୋଉଟା ଆର୍ଗୁମେଣ୍ଟ କରୁଥିଲେ, ଯୋଉଟା ଆଉ ଗୋଟେ ସେମିତି ତା ଦେହରେ ଫାଇଣ୍ଡିଂ ଗୁଡାକ ସି ରିପୋର୍ଟର କିଛି ପଚରା ହେଇନଥିଲା, ତାକୁ ୟୁଜ କରାହେଇଥିଲା। ତେଣୁ ସିଏ ଯେତେବେଳେ କଲେ ଡିଭିଜନ ବେଞ୍ଚ ରିଲାଇଂ ଅନ୍ ଦି decision of I think CJI's judgment, Chief Justice of India, ଯିଏ କହିଲେ ନାଇଁ ଆପିଲେଟ କୋର୍ଟ ମଧ୍ୟ ତାଙ୍କୁ ଅପରଚ୍ୟୁନିଟି ଦେଇପାରିବ। ସେ ତେଣୁ କ୍ୱେଶ୍ଚିନ୍ ଫ୍ରେମ୍ କରିଦେଲେ, କ୍ୱେଶ୍ଚିନ୍ ଫ୍ରେମ୍ କରିକିନି କହିଲେ ଆଇଦର ତଳ କୋର୍ଟକୁ ଯିବ ନହେଲେ ଇଏ କରିବ। ଏଠି ସେ ନିଜେ ତାକୁ ପ୍ରଶ୍ନ ଗୁଡାକ ପଚାରିକିନି ତାକୁ ଅପରଚ୍ୟୁନିଟି ଦେଇଦେଲେ। এবং that form the additional accused statement.
Yes,
ହେଲା ତେଣୁ it is not that it is helpless.
Yes.
The appellate court can also take if
Free-
it is not
free
yes,
time to-
so bring that decision also that is there.
Yes.
I think in that case also it has been done. Additional
It-
accused statement has
Yes,
been
that has been done. Yes. There also I was the counsel.
Additional ଆମେ ଏଇ ଯୋଉ ଇଏ ପ୍ଲେସ୍
ଏବେ
କରୁଥିଲେ
ଯୋଉଟା
ଏବେ ଯୋଉଟା अरे जस्टिस संजय मिश्रा and justice Savitri Rathod, they recorded the addition.
they record ଆଗେ ସେଟା ଦେଇଦିଅ ଯଦି ଅଛି ତାହେଲେ ଠିକ ଅଛି we'll
And it is very easy. The accused is here before us.
Yes,
ହେଲା
yes, yes.
ଏଇ ଯୋଉ ଦି ତିନିଟା କ୍ୱେଶ୍ଚିନ୍ ଖାଲି ଫ୍ରେମ୍ କରିଦେଇ ତାକୁ ପଚାରି ଦେଲେ କାମ ଛିଣ୍ଡିବ ଯଦି ସେ ଡିସିସନ ଟା ତେଣୁ ସେଟା କିଛି ଇଏ ନୁହଁ. Why will send it to trial court? Why will not record it? Let him answer.
But if you accept, so far as the safe custody part is concerned, then all this part becomes irrelevant.
କୋଉଟା?
The question relating to safe custody of the article for 15 days.
that the very custody of this is that
That's a different matter. That's a different matter.
If that
But,
is accepted, then all these submissions becomes
no.
loses its significance.
The court finds that there is there is a defect in accused statement or something has been omitted by the trial court.
the documents are there.
It is not that automatically ମାନେ ଯେ ସେଇ ଗୁଡାକ ସେଇ circumstance ଗୁଡାକ ତା against ରେ use ହେଇପାରିବନି. appellate court ର power ଅଛି ତାକୁ
additional evidence.
additional accused statement କରି ତାକୁ opportunity ଦେଇଦବ ଯେ ସେଇ ଜିନିଷରେ so that earlier କଣ ଥିଲା କି ଯୋଉ question ତମେ ପଚାରି ନଥିବ ସେ accused କୁ ଦେଇ ନଥିବ
cannot be taken into consideration.
but they say that sometimes inadvertently ହଉ ବା ଯାହା ବି ହଉ ପଚରା ହେଇନି କେତେ ଗୁଡାକ material ଇଏ କିନ୍ତୁ that has been used by the trial court for convicting ଇଏ ତେଣୁ ସେଇ point ଗୁଡାକ appellate court raise କଲେ ତେଣୁ ସେଠି ସେମାନେ କହିଲେ ଯେ honorable chief supreme court କହିଲେ ଯେ ନାଇଁ ତାକୁ ତାର ଗୋଟେ way out କାଢିବାକୁ ପଡିବ ଯେ ଏଠି question ହଉଛି prejudice appellate court କୁ ଯଦି ଦେଇଦେଲେ ସେଇ ଯୋଉ ଇଏଟା cure ହେଇଯିବ ସେଟା.
It is plus 2001 volume 10 SCC page 372. State of Delhi administration versus Dharampal. Failure to section 313, failure to draw accused attention to inculpatory material to enable him to explain it in examination of accused under section 313. Hell by itself doesn't vitiate the proceedings. Prejudice, if any, caused to the accused must be established by him. It is also open to the appellate court to call upon the counsel for the accused to show the explanation which accused had to offer in respect of the circumstances established against him but not put to him. On facts held in that is a food adulteration case. No prejudice had occasion to the accused on omission to put to him the contents of the certificate of director Central Food Laboratory while recording his statement under section 313. But the prosecution is dependent on any report or certificate. It is enough to draw the attention of the accused to it, not necessary that his attention be specifically drawn to the contents of such report or certificate. Paragraph.
ଏବେ ଯୋଉଟା ଆମେ କହୁଛୁ ଯୋଉଟା ଯୋଉ ଏଇ କେସ୍ ଟାରେ ରିଲା ହେଇଥିଲା ରେକର୍ଡିଂ ପାଇଁ ଯୋଉଟା କହିଥିଲେ ଯେ appellate court has power to
ଏଇ ଜଜମେଣ୍ଟ ଦେଇଥିଲି
appellate court has power to record additional accused statement.
Yes. That is 391.
391 pura. 391 ର ପାସକୁ ଇଏ କରି additional evidence ମାନେ accused statement record କରିପାରିବ. ଆଜି ଯୋଉ ମ୍ୟାଟର ନଥିଲା ଯୋଉଟା ଡେଫର ହେଲା ତା ଦେହରେ ବି
ଜଜମେଣ୍ଟ ସେଇଠୁ କାଢିକି ଦେଖୁଛି ଏଇ ଜଜମେଣ୍ଟ ଦିଟା ମୁଁ ସେଟା ଦେଇଥିଲି
ନାଇଁ ଆଜି ଆମେ ଯୋଉଟା
2/2019 first one item 1 ଏଇଥିରେ युवराज अंबर मोहिते वर्सेस स्टेट ऑफ महाराष्ट्र another judgment of the Supreme Court Then 2006, volume 12, SEC 512. Then section 313, failure to draw accused attention to inculpatory material, attention of accused not drawn to the contents of forensic report. Held the same doesn't vitiate the judgment of conviction and sentence as accused are not prejudiced thereby.
जोटा सेटा की रेकॉर्ड कर देवाशीष पंडा रा केस रेकॉर्ड सेटा केते नंबर आइटम थिला
19
ओके हां एटा तो 2 of 2019 2 of 2019 ने जोटा काढिलो सेटा जस्टिस संजय
2 of 2019
आरन
2 of
2019
हां से ऑर्डरटा
से ऑर्डर
से ऑर्डरटा रे से डिसनटा रेफर हिचो नहीं नहीं सेटा ने जोटा रेकॉर्डिंग करले
Making such request was prevented from presenting the evidence trial court by due diligence, being evident or that in fact giving rise to such prayer came to light at a later stage during financial year, and that non-recording of such further evidence might lead to failure of justice, and that the power of under Section 91 CRPC is to be exercised with great care and of either of the parties.
That is the order dated 23/12/2020 जो थे 23/12/2020 रो order टा देखिए से डेथ रेफरेंस नंबर 2 of 2019 23/12/2020 सब डिसीजन गुडा भी रेफर हिस्ता जे
11/1/2021 रे एग्जामिनेशन
23/12/2020 डेथ रेफरेंस नंबर एटा the प्रथम डाबा 2 of 2019 2 of 2019 order dated 23/12/2020 हाँ paragraph third sub parajuta. At the outset, this court found that in course of argument and examination of the impugned judgment that the condemned prisoner public appellant was not put any question on the result of the chemical examination and DNA profiling. And also it is apparent to from the order sheet maintained by the trial judge that no opportunity was given to the condemned prisoner hyphen appellant to lead evidence. So and so argued that the question regarding result of so and so has not been put to the condemned prisoner and therefore entire trial is vitiated. He further argues in another death reference case, this division bench having been taken into consideration so and so, has recorded the statement of Swanso under section 313 statement. According to Swanso, condemned present that such examination is perhaps not proper, as in the case of Sujit, Honorable Supreme Court held that in an examination Swanso, omission to put question is a material for the accused would entail acquittal. Mr. Pandal and counsel for the condemned prisoner argues that the reported case Swanso reported in Swanso on the question of sentence. On the submits that in a Swanso is reversed on the federal submission, then we have carefully gone through the two judgments of the Honorable Supreme Court that were taken note of by the separate death sentence. Now the question that arises before is whether the failure of the learned trial judge, this is most important, the failure of the learned trial judge in putting some questions relevant to prove the case of the prosecution will automatically entail a reversal of the judgment of conviction, or the appellate court has some role to play. We take into account the observation made by the Honorable Supreme Court in the case of Janak Yadav versus State of Bihar, so and so. Honorable Supreme Court examined the consequence of non-examination of the accused under section 313 CRPC. We find it appropriate to quote the exact words used by the Honorable Supreme Court in the said paragraph. Then they quoted it, so and so. Okay. It was open to the High Court to have either examined the accused whose statement under section 313 had not been recorded itself under section 313 CRPC, and then proceeded with the hearing of the appeal and directed a retrial of the case confined at the stage of recording of the statement of the appellant. Stage said it was not justified to order for retrial of the entire case by framing a de novo charges. In the case of so-and-so, Delhi High Court reported in so-and-so, we are therefore of the opinion that since the condemned prisoner was not asked certain question regarding result of chemical examination and DNA profiling by the learned trial judge, it would not be expedient and in interest of justice to reverse the finding and to record the judgment of acquittal. In our considered view, those questions which have not been put to the condemned prisoner appellant during the course of trial in course of the examination under section 313 of CRPC can be put to the condemned prisoners appellant in this court. Otherwise, it will lead to miscarriage of justice and would damage the social defense. Similarly, inadequacy of opportunity of hearing on the sentence at a sentence of requirement. Hence, we consider it appropriate to direct the production of the condemned prisoner appellant to ask him whether he wants to lead evidence on the question of sentence. We also consider it appropriate to put those questions which are relevant in an additional examination under section 313 CRPC, on the basis of which additional accused statement will be prepared separately. So the registry is directed to intimate so-and-so for production. ସେତେବେଳେ ଏ ସ୍କୋପ ନଥିଲା, ଭର୍ଚୁଆଲ ମୋଡ ନଥିଲା, ତେଣୁ ଏଇଟା କରି ତାପରେ ସେ ରେକର୍ଡିଂ କରିଦେଲେ। ତେଣୁ ଯଦି ଏଇ କ୍ୱେଶ୍ଚିନ୍ଟା ପଚରାଯାଏ ଯୋଉ ତାହେଲେ ଆପଣ ଯୋଉଟା ୟୁଟିଲାଇଜ ବର୍ତ୍ତମାନ କହୁଛନ୍ତି ତାହେଲେ এটা ଆମେ ସୋ ମୋଟୋ ପାୱାର ଏକ୍ସରସାଇଜ କରି এটা ବି ପଚରା ହେଇନି, we can put it that Lungi of the appellant ତା ଉପରେ ଯୋଉଟା ବାହାରିଛି ଏବଂ ତାର phase 2 जोटा बाहर
Figure of whatever but the result.
result of
Result of
accused Nobin, he must have been sent also for medical examination.
Nobin.
forwarding report.
Yes, Milords, in the forwarding report it is there.
Forwarding report ଲେଖା ହେଇଛି medical examination ପାଇଁ ପଠା ହେଇଥିଲା
ଆଜ୍ଞା
ତା medical examination report
Report
କାଇଁ
ଅଛି।
କାରଣ ଆପଣ ଯୋଉ ଆଣିଲେ ନା ସେଗୁଡା ସବୁ ସେ ଯୋଉ ତାର
ହଁ, yes।
ବ୍ଲଡ ଗ୍ରୁପ ମାନେ ସେଗୁଡା ସବୁ ମେଡିକାଲ
ସେଇଟା
ତ ଆଇଓ ଆଉ କରେକ୍ସନ
scientific
ତେଣୁ ସେ ନାଇଁ ନାଇଁ ସାଇଣ୍ଟିଫିକ ଅଫିସର ଦେଖିଲେନି ସେ ଯୋଉ ବ୍ଲଡ ସାମ୍ପଲ ନିଆ ହେଇଛି ଡ୍ର ହେଇଛି ଆକ୍ୟୁଜ ଦି ଜଣଙ୍କର
ଆଜ୍ଞା
ସେଗୁଡାକ ନିଶ୍ଚୟ ସେ ମେଡିକାଲ ଏକ୍ସାମିନେସନ ବେଳେ ଡ୍ର ହେଇଥିବ
ଆଜ୍ଞା
ତ ସେଇ
ten
ସେ ତାଙ୍କୁ କିଏ ଏକ୍ସାମିନ କରିଥିଲା ତାଙ୍କର କିଛି ଅଛି କି ଏକ୍ସାମିନ ହେଇଛି କି ଆକ୍ୟୁଜ ଦି ଜଣ particularly ନବୀନ
The forwarding, it is attached to the forwarding report.
forwarding report
In its forwarding report, it has been mentioned 161 statement, medical report, examination report.
PW10
PW10
10
let us see
PW10 you'll also get it as page 100 one
PW10 ତ ହଉଛି scientific officer
see the drug ଅଛି
ଓ ସେଇ କଲେକ୍ଟ କରିଛି କି
ଆଜ୍ଞା
ନାଇଁ ମୁଁ ଆକ୍ୟୁଜଡ ମାନଙ୍କର କହୁଛି
Accused ଯେତେବେଳେ ସେମାନେ arrest ହେଲେ ନେଇଥିବ ନା ଇଏ ଆଇଓ
Absolutely. Just I'm fine. ଦେଲା କିଏ ତାକୁ ସେଇଟା ହଉଛି କଥା
PW6 ତ ହଉଛି PM ଡକ୍ଟର ଆଉ କିଏ ଡକ୍ଟର ରହିନାହାନ୍ତି
He is the only doctor. There is no other doctor.
ସେଟା କେବଳ ଆଇଓ କହିଥିବ ରହିଛି ବୋଲିକିରି
ହଁ ଆୟୁ କହିଛି ଆୟୁ PW20 କହିଛି ସେଇଟା
PW20
PW20
ଦେଖିଲା ମେଡିକାଲ ଏକ୍ସାମିନେସନ ପଠେଇଲା କୋଉଠି କହିଛି ଆରେଷ୍ଟ କେବେ କଲା
ଆରେଷ୍ଟ କଲା 22 ତାରିଖରେ
22 ତାରିଖ
yes sir
on the same day on scientific officer visit କଲେ I dispatched the dead body for postmortem. On the same night, I took acha. 6 number paragraph re page 128 re. On the same night,
I took custody
I
of both the
took
accused.
custody of both the pipe. Acha, on both the accused. Thereafter, I returned to the police station gala. That 8 number paragraph huchi. I examined both the accused, arrested him during interrogation gala.
Leading to discovery.
Weapon gala. Tapore, on
Nice.
the same day, I returned to the IO, seized the wearing apparels of both the accused. This is the seizure list. And
both accused persons for their medical examination.
I sent, এটা হচ্ছে most important. I sent both the accused persons for their medical examination to S.D.H. Kuchinda, as well as collection of their biological materials. The staff of the police, namely Joydev Majhi and so returned to PS with biological materials of the deceased and their wearing apparels. On production, I seized so of all the 3 deceased. এটা হলো ডিসিজড করো তারপরে এসআই Dilip Kumar Behra returned to PS with the biological materials of both the accused. From SDH Kuchinda, I seized the same and prepared the seizure list. Seizure list is exhibit 19.
PW16 is that SI? PW16 is that SI?
Dilip Kumar Behra.
For collection of the biological material.
Biological material. P exhibit P 19 that you dekhile P19
page 261 loss
261
page 261 volume 2
Kumar Behra. This is with A sign as sealed envelope containing hair sample of Naveen Deori. Sealed envelope so and so Naveen Deori. Blood. J1 J2. Hindi Hemanand to Kurkan. Blood sample. Mr. Katkia, we'll pass that order like the other case. We'll pass that order and we'll record that accusation tomorrow.
In the interest of justice, that's it.
That is because it is necessary. So, Mr. Sadangi.
Yes, please.
This accused statement, if you want to tell something to your client, you can record. We'll just record the additional accused statement of that. Not the other. Only Naveen. Just to show the finding of the forensic science laboratory, it has not been put. So we'll pass the order today and we'll put the question tomorrow because he's on. See, Achito. Please.
ସମ୍ବଲପୁର ଜେଲ୍ ଅନମ୍ୟୁଟ୍ କରନ୍ତୁ।
ଠିକ ଅଛି ଅଛନ୍ତି ତ 2 ଜଣ ଯାକ ବାପ ପୁଅ okay advocate is there so you can also talk to that advocate about the questions which is to be framed on this finding so
better the learned friend who is there he is conversant with the language
your name learned counsel
Yes, yes, Your Honor. Sir, comfortable with Odia English both languages.
Your good name, please.
Subal Gadia, sir.
Subal Gardia.
Okay. The sum up 2 or 3 questions we want to put the accused in the accused statement, because about the finding of the FSL that has not been put. So this blood group which was found in the is a lungi and the waist, that will be put. We will prepare the questions today and we will ask the question only on this finding of the scientific officer's report. So the Nabin is to answer it. So you just tell them that this will be done. He has to just answer that. Okay.
Yes, Your Honor.
Yes, you can carry on that argument. Yes.
One order of the Lorentz session judge, that is ordered at 1/5/2023 at page 330 of the second.
Acha, Mr. Katkia, have you received that order which we passed?
Yes, already I have said.
Okay. Because that is likely to come on 10th na 10th. Okay. Yes, anything?
Yes, that is ordered at 1/5/2023, that starts from page 329. Only for, I am bringing to a lordship notice.
Page 29.
329, it starts from 329.
Second paper book.
Paper 2, volume 2.
Volume 2 ro 329.
The order sheet.
Regarding
that P31, that chemical examination report has been marked as exhibit without any objection. Only
no, that is marked. Mark ক্ষেত্রে কিছু অসুবিধা নাই। Mark হয়েছি, but
only I am bringing to lordship.
Just we have to.
Are marked on behalf of the prosecution without objection. That will also get to page 330. And P31 is the C report.
Difference 2019. Yes, you proceed.
Yes, please.
You have noticed that C report has been marked on admission.
Yes, boss. P31. P31.
P31. Okay.
Now, what questions have been put to Hemanand Dehury during recording of his statement nursing 313 CRPC? That's very specific purpose.
No, from his dresses, anything found out?
No.
Matale how come? So only question that is to be put to Naveen.
Naveen, only
Right,
Naveen.
right.
And question number 4, because Naveen and there I want to show that Naveen and Hemanand both came together to the second spot of occurrence. In that regard, plus questions have been put to them, put to Hemanand Dehury. So some question number 4, question number 14, 15 and 21. Just I am placing for Question number 4, it appears from the evidence of Pillar 1 that from their outer veranda she saw that while her mother Pirovati was pumping the tube well and the deceased Savitri was fetching water in a bottle, yourself and your father, the accused Naveen Dehury, came and accused Naveen dealt a blow by means of an axe on the neck of Pirovati, and while Savitri went for rescue of Pirovati, you restrained Savitri and dragged her hair, and thereafter accused Naveen gave 3 to 4 blows on different parts of the body of Savitri by means of the tangia. As a result, she died at the spot. What I got to say, he has stated that micho kotha mu gaare nathili. Then question of 14, also it has been put to them, like it appears from the evidence of Pillar 3 that after their departure himself, his sister and aunt, Mausi, Manika Brusset, came out of the house and saw that while her grandmother was pumping the tube well situated at a little distance from the house, you and accused Naveen came to the spot, and by that time accused Naveen were holding a tangia. He stated micho. Question of 15, it appears from the evidence of Pillar 3 that accused Naveen dealt blows by means of tangia to his grandmother Pirovati, and while his mother Savitri prevented accused Naveen, you restrained her by dragging her hair, and thereafter accused Naveen assaulted her mother Savitri by means of tangia. That is micho. And one more question on that point. 21, it appears from the evidence of Pillar 4 that while her mother Savitri went for rescue, you restrained Savitri by dragging her hair, and accused Naveen assaulted Savitri by means of such bodia, whatever what say micho. This for a specific purpose I have submitted for lordship. Only again to analyze section 34 of the Indian Penal Code. Here, how Hemanand alias Mantu has shared the common intention with his father, Naveen. Both, plus number 1, both came to the second spot of occurrence together. And as is evident now, by the time both came to the second spot of occurrence, Naveen was carrying bloodstains on his wearing apparels.
Who has
patches? Naveen. Naveen was coming along with that axe after the first incident. Was coming to the second place of occurrence where Hemananda joined.
Just a minute. Naveen yeru milila jo
Vestru au tar lungiru.
That means after the first
incident.
Setele Naveen blood ta yere thila, vest re thila. Okay.
I would also have forgotten that axe was also carrying blood.
Okay.
Though it has not been, grouping could not be done, but it was carrying human blood. That I have forgotten with due apology.
Acha, by the way, when we are putting the questions to Naveen instance re jota milichi ta pacharaichi to?
Sir, this question question 71. It appears from the evidence of PW 20 that she sent the wearing apparels of yours and accused Hemananda to DFSL sample put for UV light test and received the report which has been marked as P30. P30 is the report.
Yes. P30 is
P30 is what?
P30 is spot demarcation report.
Oh, none.
Received from Tahsildar Bamra.
P31.
Yes. P31 chemical agent.
Oh, that is chemical agent. P31. exhibit 29 P30
ସିରିୟଲି କରି ପଚାରିଛି ଆଉ 31 ଟା
ସେ
ପଚାରି
ଗୋଟେ
31 ଟା ମିସ୍ କରିଦେଇଛି
because otherwise he has gone serially and that is missed.
inadvertently କରିଛି ଆଉ
That is.
yes so first of all that they came together
Plus.
and when they came together at that point of time the wearing apparel that means
Naveen.
waist acha waist of Naveen
was carrying blood
was having blood which matched
yes
with
Giridhari.
the blood group of Giridhari.
Giridhari and maybe Savitri or Piruvati because that is group B. Because Savitri, Piruvati and the accused Naveen.
ଆପଣ ଯେତେବେଳେ ଆସିଲା
Yes.
ସେତେବେଳେ ତ ଆଉ
ସେତେବେଳେ yes
ସେତେବେଳେ
Giridhari.
obviously ଭେଷ୍ଟ ରେ
Obviously
କେବଳ
Obviously Giridhari.
ବାକି ଯୋଉ ସ୍ପଟ ରେ ପହଞ୍ଚିଲା ପରେ ଆସଲ୍ଟ ହେଇଛି ସେତେବେଳେ ଏ ଦି ଜଣଙ୍କର ବ୍ଲଡ ପଡିଛି ହେଲା ହଁ okay this is a second limb of so far as 34 is concerned of Hemanand's sharing of common intention
and in all probability that blood must be fresh because
Which one?
within few minutes
okay.
that blood must be fresh and visible to
he
Hemanand.
just came through that shortcut road that means the 800 meter ଦେଖଉଛି ସେତିକି ବାଟ ଆସିକି ପହଞ୍ଚିଥିବ ଆଉ କଣ ସେଟା and
he was holding an axe. He must be in a violent mood, which very well can be understood by Hemanand that yes, he is joining his father was already committed a crime.
ଭେଷ୍ଟ ର ଇଏଟା ଯାଇଛି କେତେ ନମ୍ବର ସେଟା ଦେଖଉଥିଲେ ଆପଣ ଆଚ୍ଛା one blue color vest
ଥିଲା
ହଁ ସେଟା ହଉଛି 141 ର ହଁ ସେଟା ଇ
147 ର ଅଛି ଇ serial number 6 একজন মাটা ই
ଗୋଟେ ପ୍ୟାଚ୍ ଏଠି ଦେଖଉଛି ମାନେ ଆଉଟକମ୍ ଦେଖଉଛି 147 ରେ ଗୋଟେ ପ୍ୟାଚ୍ ଅଫ ବ୍ଲଡ ସେଟା
ବ୍ଲଡ ପ୍ୟାଚ୍ ଅଛି almost ବହୁତ ଜାଗାରେ ବ୍ଲଡ ପ୍ୟାଚ୍ ଅଛି
ହଁ ତେଣୁ
because it is fast and once the blood comes there blotting is there
ହଁ ଗଞ୍ଜିଟାରେ ହବ obviously ଆଉ
and H plus you also can mark at page 147 H that is the weapon of offense that was carrying blood of human origin but grouping no opinion can be made H 147 at the bottom
ୟା ଉପରେ क्वेश्चन ପଚରା ଯାଇଛି
ଟିକେ ଭେରିଫାଇ କରିବ ପଚରା ହେଇଛି
ମାନେ ଆପଣ ମୁଁ କେବଳ କହୁନି ଯେ ବ୍ଲଡ ସି ଆଣିକିନି ଦେଲା ତମେ ଯୋଉ ଏଇଟା ଆଣିକିନି ଦେଲ ତାକୁ କେମିକାଲ ଏକ୍ସାମିନେସନ ରେ ସେଥିରୁ ହ୍ୟୁମାନ ବ୍ଲଡ ମିଳିଲା ଏ क्वेश्चन ପଚରା ହେଇଛି ତ
ଭେରିଫାଇ କରିଛି
କାରଣ ପଚରା ହଉତେ ସବୁଗୁଡା ପଚରା ଦିଏ
କେତେ ହେଲା
EW20 ର ଏଭିଡେନ୍ସ ରେ ଥିବ ସେ ଯୋଉ ଲିଡିଂ ଟୁ ଡିସ୍କଭରି ଉପରେ क्वेश्चन ପଚରା ହେଇଥିବ ପ୍ରଥମେ ପଚରା ହେଇଛି କି ନାଇଁ ଦେଖନ୍ତୁ ଯଦି ନ ପଚରା ହେଇଛି ତ ପଚାରିଦବା ତା ସହିତ ଏଇଟା ହ୍ୟୁମାନ ବ୍ଲଡ ଟା ପଚରା ହେଇଛି କି ନାଇଁ हाँ एक क्वेश्चन नंबर 65 को पढ़े आसंतु पेज नंबर होची 59
Max. Nabinra. Yes.
Nabina.
You brought that the said acts kept inside the hip and produced the same before P20. In the witnesses, which was seized at the spot by P20 and prepared the details by P15.
এটা তো এইটা ମାନେ ପଚରା ଯାଇ ଯୋଉଟା ବାହାର କରି ଆଣି ଦେଲା
ଆଜ୍ଞା।
ତାପରେ ସେଇ ବ୍ଲଡ ରେ ସେଇ ଯୋଉ ଇଏଟାରେ ମିଳିଲା ହ୍ୟୁମାନ ବ୍ଲଡ ସେଇ କ୍ୱେଶ୍ଚିନ୍ ଟା ପଚରା ହେଇଛି କି ନାହିଁ ଲଜିନି ପଚରା ହେଇଥିବ ବୋଲି
ଏଇଟା ଯୋଉଟା
71
Not there.
ସେଟା ହଉଛି ଏକ୍ସିବିଟ୍ P30 ଏଇଟା ହଉଛି ଫାଇଣ୍ଡିଂ ଟା ହଉଛି ଏଟା P31
That part is not there.
Result of chemical has not been.
extra arts ro human blood finding ଟା
No, not available.
ନାଇଁ ପଚରା ହେଇନି ଦେଖି ସାରିଲି ଓକେ ଆଉ କଣ 34 ଆଉ କଣ କୁହନ୍ତୁ ସେ ଯୋଉ ହେମାନନ୍ଦକୁ ଆପଣ ଆସୁଛନ୍ତି ନା କନଫାଇନ୍ କରୁଛନ୍ତି ଦି ଜଣ ଯାକ ସାଙ୍ଗ ହେଇ ଆସିଲେ ଯେତେବେଳେ ଆସୁଥିଲେ ସେତେବେଳେ ତାର ରକ୍ତ ଦାଗ ଥିଲା ଗଞ୍ଜିରେ ଭେଷ୍ଟରେ ହେଲା ସେ ଯୋଉଟା କି ମ୍ୟାଚ୍ କରୁଥିଲା ନବୀନର ସରି ଗିରିଧାରୀର ବ୍ଲଡ ଗ୍ରୁପ ଠିକ ଅଛି then
axe that was stained with blood.
axe was stained
with blood. After giving so many blows when that person, the accused, was coming, he must be in a very violent mood. And Hemanda joined him, and both are father and son. And when the axe blow was given to Pirovati, the second deceased, her daughter Sabitri, the third deceased, tried to rescue her mother.
Axe blow given to first hochi Pirovati.
Pirovati.
Then कौन था ना से झियटा ना जो Sabitri
the third deceased.
Okay, Sabitri tried to rescue
her. And she was restrained by
Hemananda by catching the tuft of hair.
And taking advantage of the same, or that facilitate, because Nobin gave several blows on Sabitri thereafter. One blow has been given to Pirovati, and she fell down because almost all the neck was caught. And then immediately she gave all the blows on the face and neck from the front side.
So all the blows on Sabitri, I think it is 4 na chatta na tinda tinta bodhe itho ki chat
I think 3
three blows
tinta acha all the 3 blows
all chopped wound, one chopped wound of size
ठीक है all the 3 blows on Sabitri given from the front side according to you because he was holding that was it was possible made possible
And Hemanand, even being the son of Navin, has never tried to restrain his father.
Acha.
And ultimately both left together. Both left the spot after the occurrence because these people
I think they shouted
Yes.
also.
Yes.
Both of them shouted that we have
Yes.
this man killed. Sure.
There are three versions, Miller. So far, the South is
Who
concerned.
will just go? Shouted.
PW1, that both of them shouted, both of them killed. PW3, only Nabin shouted, both of them killed. PW4, Nabin said, I have killed.
Then they decamped, they left the
They
spot.
went to their house without touching any of this lady or informant or any children. That's what the informant says. They did not try and even
1, 3, and 4, they entered into their house. Then they shouted. Then other people came for their rescue. What has happened? And PW9 also has stated he was sleeping on getting the noise. He came down and he saw that yes, all these two persons are dead and lying on the one is near the table, one is on the village road. And the very presence of what is the I mean presence, how the presence of Heman has given courage to Nabin, because Hemanand happens to be the son of Nabin. Because when Nabin is present, I mean Nabin is giving the blows in presence of his son Hemanand, he must be getting a courage because my son is there. So there may not be any problem for me because it is a village road, and occurrence is taking place, and that person is giving blows with one axe. There is every possibility that other persons may intervene, and there may be a life risk to Navin. But because of the presence, it is a passive loss. It's a passive, in a passive way, he has shared the intention with his father. And the very relationship between the two are father and son, inseparable. In case of any emergency, in case of any risky situation, they are not separable because one will come to the rescue of the other. And plan is, you also can find the plan. The plan must be that I will hit, I will kill all those persons, you don't kill.
Sorry for the interference. Mr. Katiga is not audible. Sorry, Mr. Katiga is not audible.
that is very apparent on the face of the post-mortem report. And there is also evidence that he
got hold of restraint.
got hold of the top of the hair. So in that position,
so obviously, he shared the intention with his father, and his father has done two crimes just before it, because Pedal 1 has stated, both have said that yes, we have killed Girdhari. Both have said. And then Pedal 3 and Pedal 4, of course, they have said that only Navin said, declared that I have killed. But both have said. So it was within the knowledge of both that one person is already dead. And in presence of, this Hemanand, one blow has been given to Pirovati, then subsequent blows have been given to Savitri. And he being the son, what he was doing. That is my humble submission to Lordship. So he shared the common intention with his father.
କାରଣ 34 ଅଛି ମନେ କରନ୍ତୁ କି 149 ଅଛି ଏମିତି ଯାଉଛନ୍ତି ଇଏ ତା ଭିତରେ ଜଏନ୍ କରିଗଲା ହେଲା ଜଏନ୍ କଲା ଲୋକ ମାରିଛି ଇଏ ବାଟ ବାଲା ଜଏନ୍ କରିଗଲା ଇ ବାଇଷ୍ଟାଣ୍ଡର ରହୁତା ତେଣୁ ସେଠି ସେ କହୁଛନ୍ତି ନା ଏଇଟା ହବନି କିନ୍ତୁ ଯୋଉଠି ଆକ୍ଟିଭ ପାର୍ଟିସିପେସନ ରହୁଛି ହେଲା like preventing the other persons to come and rescue the deceased, holding the deceased,
and not restraining his father. He is the person who he could have restrained.
Seta segudako hele ha igura sabu gudako ku apun judge karikini ye karibe kana
the other person may not come to his father, but that son could have restrained his father.
କାରଣ ଏଇ କେସରେ ଏଇଟା ହବ common intention ସେମିତି କିଛି straight jacket formula ନାହିଁ. Court has to judge, infer it from the surrounding circumstances, from what has happened at the spot, how far it can be said that he has shared the common intention.
And both the judgments, that is the ratio that court, looking at the circumstances, court can infer.
ଆଉ ଗୋଟେ decision ରେ ଥିଲା ଯେ X is the main assailant, let us say. Whether X could have committed or executed everything without any assistance from the so and so. ସେଟାକୁ ମଧ୍ୟ ସେ କେସରେ କରିଛନ୍ତି ଇଏ ଯଦି ଟୋଟାଲି କିଛି ହେଲ୍ପ କରି ପାରି ନଥାନ୍ତା ସ୍ପଟରେ ତାହେଲେ ସେ ଯୋଉ ଟାଇପର ସବୁ ଜିନିଷ କରିଦେଇ ଯାଇଛି ସେଟା କରିପାରିଥାନ୍ତା କି ଯଦି ନାଇଁ କରିପାରି ନଥାନ୍ତା ଇଏ ଯୋଉ ହେଲ୍ପ କଲା ଦ୍ୱାରା ସେଇଟା ଫ୍ୟାସିଲିଟେଟ୍ ହେଇପାରିଲା ତାହେଲେ ସେଟା that is one of the factors which can be also taken into account.
And on the other hand, let's already have submitted lordship. The father is getting courage because his son is there. Because there is also a chance, because in the village road he is assaulting two women, two ladies. There is always a risk because other villagers may intervene because his son is present. His son is present. That is the reason why he must be excited. He must have got courage out of that. That is in a passive way. He has shared the common intention.
ବ୍ଲୋ ଗୁଡାକ ଯୋଉ ହେଇଛି ସାବିତ୍ରୀ ଉପରେ obviously quick succession ରେ ହେଇଥିବ.
No videographic presentation can be made. No one can say. It's a very quick succession.
ତିନିଟା ତ ବ୍ଲୋ ଆଉ କଣ ଫଟାଫଟ.
Even Pirovati next Savitri. ଏ ସବୁଟା ମିଶିଲେ ବି ସବୁ total 4 blows. ତ exactly ଦେଖି ବି ହବନି କିଏ କୋଉଠି କେତେବେଳେ କେମିତି ମାରଲା. They must be in a state of daze and excitement. Because she being the daughter of the deceased and sister of another deceased.
No, obviously she shot. I think she locked the door or shot the door. Yes. Maybe on account of apprehension that they would come and assault him also. They have already finished 3.
Yes.
They may further finish the rest of the members. That may be the reason for which he closed the door. Did not come to the because 2 small children are there, maybe 15, 16, 7. And he is also PW. The other one is also a lady. So might not have got the courage to come to that duel and south and all these things. So that is also. So that we have noted down about
Yes,
your submission on that. That's all.
That is all.
But we are keeping this matter to
Yes,
tomorrow
for
for recording this.
reference. That reference to us.
So, Mr. Sarangi, please unmute yourself. You have not. Tomorrow at 10:30 we'll record the statement of that father. This about this Nabeen on this particular finding of this few questions we'll just ask. Then obviously this since he has finished the matter and called for that report, which we got on Friday, it has to go to 10th of July 2024. That is the okay. এই ଯୋଉ ଦିଟା ଡିସିସନ ଦେଇଛନ୍ତି ଏଟା ଟିକେ ଯେ ପ୍ରତିକ୍ରିୟା ଏଜିଏ ହଁ 34 ଏଇଟାକୁ ରଖିଦେବ ହେଲା।